Faites l'appel, s'il vous plaît, Monsieur le greffier.
Monsieur le comptable de Saint-Hélier. Madame le comptable de Saint-Laurent.
Présente.
Monsieur le comptable de Saint-Brelade.
Présent.
Monsieur le comptable de la Trinité.
Présent.
Monsieur le comptable de Saint-Pierre.
Présent.
Madame le comptable de Saint-Martin.
Présente.
Monsieur le comptable de Saint-Jean.
Présent.
Monsieur le comptable de Saint-Clément.
Présent.
Monsieur le comptable de Grouville.
Présent.
Monsieur le comptable de Saint-Ouen. Monsieur le comptable de Sainte-Marie.
Présent.
Monsieur le comptable de Saint-Sauveur.
Présent.
Monsieur le député Southern.
Présent.
Madame le député Labby.
Présente.
Monsieur le député Tadier.
Présent.
Monsieur le député Luce.
Présent.
Madame le député Dublé.
Présente.
Monsieur le député Morel. Madame le député Lahigara.
Présente.
Monsieur le député Ayer.
Présent.
Monsieur le député Ward.
Présent.
Madame le député Alves.
Présente.
Madame le député Gardner. Monsieur le député Gorse.
Présent.
Monsieur le député Farnham.
Présent.
Madame le député Moore.
Présente.
Monsieur le député Mezek. Monsieur le député Joseph. Monsieur le député Balash.
Présent.
Monsieur le député Coles.
Présent.
Madame le député Poré.
Présente.
Monsieur le député Ward.
Présent.
Madame le député Miles.
Présente.
Madame le député Scott. Monsieur le député Renner.
Présent.
Madame le député Curtis. Madame le député Feltham.
Présente.
Madame le député Binet.
Présente.
Madame le député Jeune.
Présente.
Madame le député Miller.
Présente.
Madame le député Howe. Monsieur le député Binet. Monsieur le député Ferry.
Présent.
Madame le député Kovac.
Présente.
Monsieur le député Curtis. Madame le député Ward.
Présente.
Madame le député Wilson.
Présente.
Madame le député Stevenson. Monsieur le député Andrews.
Monsieur le doyen.
Notre soit au nom de Dieu qui a fait le ciel et la terre. Amen. Seigneur Dieu, Père éternel et tout-puissant, qui a établi les gouvernements et les puissances de la terre pour le règlement et pour la conduite du peuple, et qui nous a commandé d'avoir toujours pour but la gloire de ton saint nom. Nous te prions qu'il te plaise de donner à cette assemblée le don de conseil de prudence, d'unir les cœurs et les affections de tous ceux qui la composent, de la conduire tellement toi-même par ton Saint-Esprit, que toute leur délibération est accompagnée de ta bénédiction. Réussisse au bien et du surgement du peuple, qu'il t'a plu de commettre à leurs soins. Car nous t'en prions au nom et par le mérite de ton Fils bien-aimé Jésus-Christ, notre Seigneur, qui nous a enseigné de t'invoquer en descend. Notre Père, qui es aux cieux, ton nom soit sanctifié, ton règne vienne, ta volonté soit faite dans la terre comme au ciel. Donne-nous aujourd'hui notre pain quotidien, et nous pardonne nos offenses, comme nous pardonnons à ceux qui nous ont offensés. Et ne nous envoie pas en tentation, mais délivre-nous du mal. Car à toi le règne, la puissance et la gloire, au siècle des siècles. Amen.
Monsieur le comptable de Saint-Hélier. Monsieur le député Morel.
Présent.
Monsieur le député Mezek.
Présent.
Monsieur le député Joseph. Vous jurez que Monsieur le député Joseph est tellement indisposé qu'il ne peut pas assister à cette indisposé sa santé. Madame le député Scott.
Présente.
Madame le député Stevenson.
Defer. Les États sont constitués. So we resume the debate on the articles in second reading of the Assisted Dying Jersey law, and in accordance with the running order, we had reached point 4 of the running order, which is the amendment, the second amendment, section J of the second amendment lodged by the Minister for Health and Social Services. I invite the greffier to read section J of the second amendment.
Page 139, Article 5. In Article 5.6, paragraph 2F, substitute paragraph 2G. Page 194, Schedule 3. 2. In Schedule 3, existing paragraph 5.3, renumber new Article 21A as Article 21AA. 3. In Schedule 3, after existing paragraph 6.2, insert 3. In Regulation 81A, in the table, row 7, third column, for paragraphs 1 to 5, there is substituted paragraphs 1 to 5A. And 4. In Schedule 3, renumber existing paragraphs 1 to 6 and cross-references accordingly.
Minister, I invite you to propose section J of your second amendment.
Sir, this part of my amendment makes a small number of referencing corrections, one to this draft law and others to regulation of care, with those corrections required in response to the Assembly's recent decision to introduce independent regulation of hospital services under P.65 2025. These are simple amendments and I hope members will agree to them. Thank you.
Is section J of the second amendment seconded? Does anyone member wish to speak? And if no member wishes to speak, would members in favour of the second amendment kindly show? Section J of the second amendment is adopted. Then we move on to point 5 of the running order, and I invite the greffier to read the first amendment.
Sir, may I raise the defer on Deputy Stevenson?
Members agree the defer can be raised. Defer is raised.
Page 143, Article 8. 1. Delete Article 8 to G2. 2. Delete Article 8.5 to 7. 3. Renumber Article 8 to G3, 8 and 9 cross-references accordingly. Page 144, Article 9. 1. Delete Article 9.1k. 2. For Article 9.2c1, substitute 1. It is appropriate to carry out the assisted death if the practitioner is satisfied that the individual has that capacity and reasonably believes that the final request is voluntary. 4. 3. Page 146, Article 10. Delete Article 10 to C. Page 149, Article 17. 1. Delete Article 17.4. 2. Renumber Article 17.5 to 8 and cross-references accordingly. Page 153, Article 23. In Article 23.1c, delete 6 or. Page 155, Article 26. In Article 26.1c, delete 6 or and 8 to 8a or. Page 155, Article 27. In Article 27.6, delete 6 or and 8 to a or. Page 165, Article 42. In Article 42 to D, delete 8.6a or and 6 or.
Thank you. I invite Deputy Barbara Ward to propose the first amendment.
Thank you, sir, and members. May I start by thanking the Health Minister for his understanding in me bringing this amendment for debate. As politicians, we are the lawmakers, and it's our duty to raise issues if one feels more debate, clarification and scrutiny needs to happen to ensure that we are satisfied that all is safe, fit for purpose and legally in order. This amendment that I'm bringing is not about redebating the main principles of the assisted dying law, which has been agreed by the Assembly. But specifically, I'm challenging the articles as set out in my proposition, pertaining to the waiver of requirement for future capacity. We call the waiver. With further explanation which, if you desire, is on page 22, item 95 of the draft law report and its associated articles. To recap, the draft law introduces a waiver of requirement for future capacity at stage 6 of a 7-stage process, with the person administering practitioner to confirm procedures with an assisted death, ensuring that the person at that point has full capacity, who then signs the waiver. We've been advised at numerous briefings that the stage 6 is approximately around 2 to 3 days before the person's natural passing. The signed waiver purports to give the administering practitioner the go-ahead to administer the terminal solution if the person loses capacity or has drifted into a sleep or coma. The reasoning behind purports to protect autonomy, which in my view raises significant ethical and practical concerns. Stakeholders have identified the risk of fluctuating capacity, ambiguous expressions of refusal, and lack of contemporaneous consent. The panel noted that practitioners' willingness to act under a waiver remains untested and must be established before any agreement to implementation. I've taken some of the key findings from the panel's report, if I may, sir. Capacity assessments in assisted dying require enhanced safeguards and specialised training. The waiver poses significant risks, including potential coercion, misinterpretation of refusal, and lack of contemporaneous decision-making. Practitioner willingness and feasibility remain unknown. The key recommendations from the panel include a further practitioner survey and public consultation, specifically on the waiver. Guidance on the practical application of the waiver, including fluctuating capacity and withdrawal. Training for administering practitioners on the ethical and clinical complexities involved. The panel's findings are very much echo my serious concerns as to the safety of this waiver inclusion. The whole assisted dying law is about consent and having full capacity with all the checks and balances throughout the process and up to the point of self-administration of this terminal solution. It also emphasised repeatedly in the draft law that the person can state at any time during the process to change their mind, to proceed with an assisted death, which is their human right and must be respected. The process will then be stopped. If a person has lost capacity or is asleep, they are unable to exercise that human right. It's interesting, as stated in the draft, that in Western Australia, some 28% who wish to have an assisted death change their minds at the final stage and stop the process. In my view, that is a high percentage which we must not ignore. I've made searches throughout different jurisdictions and countries, but it's difficult to ascertain what percentages there are in other countries, as the data is very woolly. Unconfirmed stats from Canada is approximately 38% decline in assisted death at the final point. Maybe the high percentage of people changing their minds the reason why people want to have an injection rather than self-medicate. The waiver is about proceeding with the administration of a terminal solution when the person has lost capacity or is unconscious and therefore unable to state their right to continue or not with the process at the point of administration. I believe it's our human right to say yes or no at the point of that self-administration. This waiver denies the persons their right to stop the process. If the administering practitioner proceeds to give a terminal solution to a person who is unable to express yes or no, then in my view, they are exercising non-voluntary euthanasia. This draft law is not clear or open about. It's interesting in the draft law that the administering practitioner can withhold and stop the final termination if they feel the person appears to be resisting, even though the person has signed a waiver. This is dependent on the practitioner's expert and experienced skills, which in my view is most uncertain. It is open to a subjective assessment. How can the administering practitioner tell whether the twitch, the flinching, the shuddering, or desperate look in the person's eyes is an invitation to stop the process? This waiver is unhelpful. It contradicts, in my view, the whole assisted dying process and its philosophy, that one must have full capacity at all stages, especially at the point of self-administration of the terminal solution. The waiver, in my view, is fraught with subjectivity, and I believe needs higher legal scrutiny of its inclusion. Presently, many jurisdictions do not have the waiver element contained in their assisted dying laws. However, it must be noted for balance and clarity in the UK that the terminally ill adults end-of-life bill is actually being considered in the House of Lords at this time. One main country to have a waiver is Canada, and they use a thing called MAID, which when you compare the waiver, when you actually read what is in Canada and what is in Jersey, Jersey appears to have based many elements on in this draft law. The Canadian law has a number of published elements shrouded in controversy. I'm asking that the assisted dying law proceeds without the waiver element at this time to ensure no more delays, as the waiver needs much more due diligence by, as I've said, by higher legal authority. Let's keep the process, and forgive me by using these words, as simple and as safeguarded as possible, with persons fully cognizant to self-administer their terminal solution. The waiver element, which I believe purports to an act of non-voluntary euthanasia or killing a person by terminating an unconscious person or a person who's lost capacity with a lethal cocktail. I'm also worried how this waiver type process would progress going forward. Will the principle be extended in time to people who've got dementia, a stroke, or maybe a serious head injury? Where would it end? We're going to see some drift. If this draft law continues with the waiver in place, I must question whether it would actually realise royal assent by the Privy Council. We need to be clear that at present, euthanasia and assisted suicide are deemed as either manslaughter or murder, illegal under the English law and punishable with a heavy jail sentence. In Guernsey, it's illegal under the Homicide and Suicide Bailiwick of Guernsey Law 2006 and punishable by up to 14 years in prison. In Jersey, assisted suicide is illegal according to customary laws and recognised in the Homicide Jersey Law 1986. Therefore, we must as legislators respect and abide by the law that is in place. Just for clarification, assisted suicide is illegal under the terms of the Suicide Act 1961 and is punishable up to 14 years imprisonment. Trying to kill yourself is not a criminal act. Euthanasia can be classified as voluntary euthanasia, where a person makes a conscious decision to die and asks for help to do so. Non-voluntary euthanasia is where a person is unable to give their consent, for example, because they're in a coma or they've lost capacity, and another person takes the decision on their behalf, perhaps because the ill person previously expressed a wish for their life to be ended in such circumstances. And this is where the waiver crosses over and becomes euthanasia, in my view. Therefore, sir, this waiver is clearly an act of non-voluntary euthanasia, which would be contrary to the UK law. Jersey would be very much out of step Whilst I respect and value opinions and views on ethical aspects, why this waiver should be in place, but sir, I will stand corrected if I'm wrong, but ethics does not trump the law. Recently, the Assembly agreed to an end-of-life proposition which will bring investment action for all facing their final journeys. Positive, palliative, pain and anxiety management and good end-of-life care across all areas of healthcare. In my view, with this, I think, landmark introduction, will melt away the need for a pathway of assisted dying, especially if it includes the most unsafe waiver. We need to focus on investing in the living and try to improve our existing health service for many, and there's much to do. We also need to know how much money will be needed to have this assisted dying service. We haven't actually got any costs, or maybe I've missed something in what I've read. If Jersey wishes to extend an assisted dying law to encompass voluntary and non-voluntary euthanasia, then this can be revisited in the future. But sir, it is not for now. If this waiver remains, then this Assembly needs to be open and transparent by changing the title of this draft law to an assisted dying and euthanasia law, which will cause more delays, controversy, as the people of Jersey have not been consulted or voted on this very serious element, which is fraught with risks and costs involved. Thank you, sir and members, for listening, and I look forward to the debate of a most sensitive issue. Thank you.
Thank you. Is the First Amendment seconded?
Yes, sir.
Does anyone member wish to speak on the First Amendment? Deputy Rob Ward.
Thank you, sir. We can't let this debate go without anyone speaking. It's too important. So this amendment removes the from the draft assisted dying law one of its most important safeguards, the waiver of future capacity. I oppose this amendment because the arguments presented for removing the waiver are not only flawed, but in several places directly contradict the evidence, the purpose of the law, and lived reality of those facing rapid cognitive decline. So the amendment claims the waiver changes the draft law from an assisted dying law to an administering practice of non-voluntary euthanasia. This is a serious allegation, but it's not supported by the text of the law, nor the international evidence, nor the safeguards already built into the Jersey legislation. Let's be clear. The waiver does not allow anyone to give an assisted death unless they have already been fully assessed, approved, and made a final request while they have capacity. It simply prevents a cruel outcome where a person who has been approved, who has made their final request, who has planned their death with their family, suddenly loses capacity days or hours before the agreed date and is denied the very choice that they fought for. The amendment itself, sir, acknowledges this when it quotes the draft law. The waiver only applies if they lose decision-making capacity after their request has been approved, but before they are due to confirm their consent during the final review. This is not euthanasia. This is respecting a competent person's clearly expressed, legal, verified decision. The amendment misrepresents the purpose of the waiver. The amendment argues that if a person becomes unconscious, they are no longer distressed and therefore do not need an assisted death. But unconsciousness, sir, is not peace. It is not dignity. It is not the death the person chose. The waiver exists precisely because some conditions, in particular neurological disease, can cause sudden, unpredictable loss of capacity. Without the waiver, those individuals are effectively excluded from the law. Their autonomy becomes a lottery. The amendment claims the waiver is illogical because distress can be easily managed with medication. But the entire purpose of assisted dying is that suffering cannot be adequately relieved, even with the best palliative care. The amendment simply asserts the opposite without evidence. The amendment states that administering drugs to a person who has lost capacity is a form of manslaughter. That, sir, I believe is inflammatory and legally incorrect. The waiver applies only after a full eligibility assessment, a mandatory capacity assessment, a mandatory voluntariness assessment, and a final request made with capacity. The person has already said yes, clearly, repeatedly, and with full legal safeguards. To claim that honouring that decision is manslaughter is to deny the validity of the person's own autonomy. So the amendment warns of a coercion from family members and bias from practitioners, but provides no evidence that waivers increase because of these risks. It simply asserts that they do. In fact, the draft law already contains, and I remind members of this, multiple independent assessments, mandatory checks for coercion, and mandatory reporting. The amendment does actually acknowledge that the practitioner can decline the process if the patient appears to resist, even while unconscious. That is a safeguard, not a risk. The amendment argues that because UK courts do not allow advanced decisions demanding treatment, a waiver should not be allowed. So I must address that. I question whether assisted dying is a treatment in the medical sense. It is a legal right exercised through a statutory process. So the amendment quotes the citizens' jury, but omits the key point. The jury supported advanced decision-making in certain circumstances for those who lose capacity. The waiver is precisely that, an advanced decision-making with capacity for a very narrow and specific circumstance. And so this is one of the key points of the consequences of this amendment. Without the waiver, and I've mentioned this previously, and this is the same theme coming through. Without the waiver, sir, two people with the same diagnosis, the same suffering, the same eligibility could face entire different outcomes because one loses capacity a day earlier than the other. So that is not safeguarding, that is discrimination based on the speed of decline. The amendment says there should be no intervention where a patient becomes unconscious or has lost the capacity and is unable to say yes or no. But the patient has already said yes. They said it with capacity. They said it through a legally regulated process, and sir, they said it knowing exactly what the waiver meant. To deny them at the final moment is not protection, sir. I would go as far to say it is abandonment. In conclusion, sir, this amendment does not strengthen safeguards. It removes choice. It removes fairness and it removes compassion, a central pillar to the right to an assisted death. The waiver is not a loophole, it is not a danger. It is humane, tightly controlled provision designed for a small number of people whose conditions may rob them of capacity right at the very end. Removing it would undermine the very principle of autonomy that this law is built upon. And so I urge members to reject this amendment and uphold a framework that respects the decisions of competent adults, protects the vulnerable, and ensures that no one is denied the peaceful death they have lawfully chosen. So I urge members to reject this amendment. Thank you.
Thank you, Deputy. The next member to speak is Deputy Scott.
Thank you, sir. Well, I think my colleague, Deputy Rob Ward, has made an excellent speech there, and I haven't got much to add to it. Essentially, this amendment requires a patient to have retained capacity at the time of administration of the drugs that will end their life. So conversely, it deprives that patient of choice. And Deputy Rob Ward mentioned discrimination, and he's summarised something that struck me about this whole proposal. It produces a perverse state of affairs. Many of us have, unfortunately, friends, I'm sure, as have I, who have been diagnosed with cancer. And I had a beautifully handwritten letter from one a few weeks ago. And she told me about her experiences as a cancer patient. and what can seem like an overwhelming number of choices she has to make regarding her treatment. And she's given all those choices. She's not a medical professional, but nevertheless, she's told, well, you can have this, can have that, and these sort of things. And she may not particularly want to be treated with drugs, or she may have, but her choice is respected. All this time, I believe that this proposition is based on a professional conviction that the patient will be well looked after at the end of their life. They may not be aware of their standard of care. They may not be in a state to care about it. And at that stage, everything that happens to them in a state of unconsciousness will be someone else's choice, professional choice, and that's okay. And I struggle with this somehow. Oh, well, when you're conscious, you can have all these choices available to you, but you can't, once you're unconscious, too bad. Now, that's for somebody else to decide. So, is that what the patient wants? Well, clearly, in a public consultation, people thought about this and thought, well, no. And here's the thing, I can create a will advising others how I wish my body to be dealt with once it's lost its life. And my life is a gift. It's an asset. And for most of my assets, to anticipate my mental incapacitation, I can create an enduring power of attorney. I can actually say, I trust people to deal with my assets in a certain way. Deputy Barbara Ward has provided statistics on how people with mental capacity can change their mind. But nothing changes in terms of if you reject this amendment. People with mental capacity can change their minds. But then we're talking about a point where they are no longer capable of doing this. And so I second the actual statements here that I believe that's that's inhumane. I have, in a previous speech, mentioned the Dutch and Spanish jurisdictions that, in my mind, are humane enough to allow patients to live the longest conscious life possible by requesting or requiring that their lives be terminated once they have lost mental capacity. And indeed, I believe that was explored, but again, there are ethical considerations with that. So what we have to do is think about the balance there. The use of the term euthanasia is highly inflammatory. The term voluntary euthanasia has been used. But here is the distinction. There is consent. And there are safeguards in this law, amazing safeguards, incredible safeguards to ensure that that consent really is voluntarily given in terms of that person saying what they want as they actually finally have this final say over their end-of-life care and how they want it to be done. Let's move on to the subject of money, since it's been provided. Money needed to provide this service. And this actually reminds me to some extent of my ombudsman work, like how much is the social benefit of something worth the cost? But in this case, I have to say, well, if you're going to go down the subject of money, why not think about the money that is being used to keep people alive without their consent? What is the cost of distress caused to families who see their relatives kept in the borderland of pain and consciousness because of a rule that they must be kept alive, come what may, even if that is not what they want? So this is not a comfortable subject, and a cost analysis would not be easy. But there is a set of which the Deputy might consider if she chooses to do so. So in conclusion, sir, I likewise will be rejecting this amendment, and for the reasons I've given.
Thank you, Deputy Scott. The next member who's indicated a wish to speak on the First Amendment is the Constable of St Saviour.
Thank you, sir. People change their minds, sir. That's why we're here, to change minds. to encourage colleagues to vote one way or not another. I have been asked by my constituents which way I'm going to vote on the assisted dying legislation. And I said I could only consider voting for it if all the checks and balances were in place. And in my opinion, this amendment, Amendment 2, by Deputy Barbara Waters and Clement, is one such check and balance. I will be supporting this. It does give me greater peace of mind that yet another check and balance would be in place if this is accepted. If it is not accepted, then it throws in doubt my willingness to support the whole assisted dying legislation. I'll leave it there. Thank you, sir.
Thank you, Konatar. The next member to speak on the First Amendment is Deputy Balash.
Sir, it seems to me that one's response to this amendment is really instinctive. It is true that from a theoretical and rationalistic perspective, if a person has made a voluntary and informed choice, there is no reason why the administering practitioner should not administer the coup de grâce. Yet, when one thinks about it, there is something rather clinical and soulless about a doctor or nurse injecting a comatose or unconscious patient with a fatal cocktail that is going to bring life to an end. The patient is lying there unresponsive, but the relevant box has been ticked, the request has been made, the appointed hour has come, and the deed must be done. What a melancholy way to draw one's life to a close, and how depressing, degrading almost, for the doctor or nurse who performs the task. I would not be in the least surprised if it proved difficult to find medics trained to preserve life who were willing to do it. As Deputy Barbara Ward says, it is euthanasia. It may lay the ground, who knows, for involuntary euthanasia for people whose lives have become, in the view of the objective observer, worthless and pointless as we slide down this slippery slope. The argument for it is based on patient choice. Deputy Rob Ward spoke quite eloquently of a choice legally made. But choice includes, inevitably, the right, as the Constable of St. Saviour said, to change one's mind. Who will know whether the patient slipping into unconsciousness, or worse, some alert state where communication is impossible, has decided not to do it and to allow nature to take its course? There is a risk that someone will be put to death who does not wish it. The Minister, very frankly and honestly, acknowledges that when, in a public hearing of the scrutiny panel, I put it to him that, on balance, you are prepared to take the risk that somebody might die who does not wish to die. The Minister said he was comfortable with that and that he was not going to please everybody. The Minister was right to make that concession because it is the case that that might happen. The Minister's position is, in the vernacular, tough luck, you've made your choice, it's too late to change it. And I think that is a bridge too far. One must allow people at the last moment, if they wish to do so, to change their minds. If people want to end their lives, so be it. But they must be consciously able to make that choice.
Thank you, Deputy. The next member to speak is Deputy Catherine Curtis.
Thank you, sir. So I do support assisted dying. I don't think someone should be expected to live with unbearable pain if they want to end their life. And the review panel has spent much time considering matters such as the waiver, listening to the experts and discussing at length this matter. And I consider this is a suitable matter to come before the Assembly before debate. Assisted dying is a matter that must be approached with extreme caution. And I understand there is a lot of public support for a waiver. But having listened to Deputy Barbara Ward's speech and her statement that the process of assessing a person's wish to go ahead or not when they've lost capacity is fraught with subjectivity, I'm persuaded that at this point I cannot support the waiver. It may be that when assisted dying has been in place in Jersey for a few years, that would be a good time to consider whether the possibility of a waiver should be brought in. So due to approaching this matter of assisted dying with caution, I will vote for this amendment.
Thank you, Deputy. The next member to speak is Deputy Brenoff.
Thank you, sir. I'm sorry to say I'm not in favour of this amendment. I'm speaking against it. The argument, as I understand it, is that assisted dying could happen when it might not be the choice of the individual. I think this amendment would actually achieve the exact opposite. The actual effect of this amendment would be to ensure that the outcome would be that the patient's decision could be overruled. We must recall that by the time this amendment kicks in, the patient would have already established a long history of unambiguous commitment to an assisted death. They would further be choosing a waiver, which would also be an unambiguous commitment. They are so certain that they want an assisted death that they are prepared to waive their final stage and in effect make the decision in advance. In these circumstances, the waiver is the final decision. At the point where a waiver becomes an option, there are actually two options available. There's a fork in the road. Each of them involves a decision, one further decision. In one situation, the patient can wait until the anticipated date of death and confirm their decision on that date. That is one of the decisions that could happen at that fork. Or they can make a decision to waive that final step. This simply shifts the time of the decision, not its nature. A final step is being asked. The waiver is that final step. Yes, the effect of the waiver is to say, yes, I'm sure and so sure that I want to go ahead, even if I lose the capacity to restate my view. The effect of Deputy Barbara Ward's amendment is to reverse the final view expressed by someone who has chosen an assisted death. Deputy Barbara Ward's report says, "It is my belief that to administer terminal drugs to an unconscious patient is not an assisted death, but an act of euthanasia or a form of manslaughter. My view is that the patient has not been afforded their right to change their mind." But they have been afforded the right to change their mind. It was at the time they chose a waiver. If this amendment passes, then something very different is happening. The patient's mind is being changed for them. Their stated view is being overruled simply because they have lost consciousness. If the question raised by this amendment is about ensuring that the patient's final view should be respected, then I think we are commanded to reject this amendment. So It was a nice ride into work this morning, and I used the time to reflect on the issues at stake here from a personal point of view. And I reflected that when I first considered what we now call assisted dying, it was at a much greater distance than today. Distant in terms of my own experience, and distance in terms of close proximity to decision making. I'm closer to confronting the issues myself now, and I'm in a position to contribute to the decisions in Jersey, and I have more lived experience. We are talking about the final days of life. I have seen that process. I've seen the point at which capacity is lost. And it is not the flicking of a switch, sometimes only apparent after the event. The waiver means that the patient's wishes are respected whatever those circumstances. If I try and imagine myself into this situation, I know what can happen if I am a cancer patient facing my last days. I've seen it. Capacity has been lost, but suffering has not. I know that palliative care experts argue that what appears to those watching as suffering is not experienced as suffering by the person who is dying. Maybe. But if I imagine myself into that awful situation, I want the right to choose not to put that theory to the test. I may not exercise that right, but I know for sure that I want the option to avoid it. And that is only possible with the waiver. Deputy Balash may think that this is a clinical end, with the act itself seen as degrading. I have to say that as I contemplate those awful circumstances, were I to find myself in them, the most degrading thing would be to have my settled view overturned at the very last moment. So I don't accept it is an act of non-voluntary euthanasia. It is not voluntary, non-voluntary rather. The waiver guarantees that the patient's wishes are respected, whether or not they lose consciousness. It is as simple as that. Thank you, sir.
Thank you, Deputy Renouf. The next member to speak is Deputy Tadier, and then I have Deputy Miller. Deputy Tadier.
Thank you, sir. I think we need to bring this back again to what the whole purpose of the law is. It's about compassion and it's about autonomy and self-determination for those who support it. And of course, there are counter-arguments, most of which we've heard, apart from the exception of Deputy Curtis, I think comes from members who didn't vote for this in the first reading anyway, so that they don't support the principle of assisted dying. And so when we're hearing most of the time of people saying, you know, this is a final safeguard, which might mean that if all of these barriers were in place, then I could possibly support the last ones. I'll be looking at the votes, by the way, of how people do vote if any of these amendments go through. Because what I see is not us actually putting safeguards in place. We had this debate yesterday. There are safeguards, lots of safeguards in place to the point where actually lots of people who might wish to avail themselves of an assisted death will be prevented from doing so, especially even in this case, because they haven't yet got to the final stage of giving that consent. So let's not forget those people. As Deputy Ward said, there will be people with a long and settled wish that if ever they get into whatever degenerative state where there's no recovery and that they fall unconscious, they wish to have an assisted death, sir. And some of those people will be prevented from doing so simply by the way we have worded the law already. And that is done on the basis of a safeguard. This would put in place a further barrier. I'll give an example. I don't know if it's a perfect analogy, sir, but I think it's an example that came into my head. There are certain religious groups that, for example, have medical preferences, sir. I think of the Jehovah's Witnesses, sir, who I have some knowledge of their beliefs. And I know one of the things that Jehovah's Witnesses don't accept is a blood transfusion. And if a Jehovah's Witness was involved in a car accident, for example, and they found themselves being rushed to A&E, taken to the emergency ward, they were unconscious and they were hemorrhaging a lot of blood, but their notes specifically said, their medical notes specifically said that they had a long and settled view and position that they would not want to take anybody else's blood, even if it meant that they died in that situation. Would it be ethically correct for the doctor to override their wish and actually give them blood to save their lives, even though they've stated that they would prefer to die than to be in that situation? Now, of course, there are lots of interventions that the medical staff can make to save that life, and of course that person would also want their life to be saved wherever possible. But if it fundamentally came down to that one proposition that they had to have blood in order to survive, I think it would be a very difficult decision for a doctor to make, and one would understand fully if that person was allowed to die in that situation because they would die in a way that they were comfortable with. That wasn't contradictory to their belief system, sir. I hope nobody asks for legal backup on that, so it's simply an illustrative point, and I don't think that's the point that we're debating today, sir. But I think it's a point that hopefully is well made. We are talking about people with long and settled views. And of course, all of these debates that we're having today, as well as the main debate, is a matter of conscience for members. But it's also highly personal, because this is a situation that we could indeed find ourselves in. What I would ask is, if we weren't members of this assembly, but we were outside the assembly, perhaps listening in, I would perhaps be asking myself the question, why should a decision that's made today in this assembly, this amendment from the backbencher, is absolutely her right to bring this, and I've said as much to her yesterday, I think it's a valuable debate to have, but why should a decision that we might make today by somebody who doesn't know me remove a statutory right that I would be entitled to under the law after I've made a settled decision? And I've deliberately signed that waiver because I've envisaged a scenario where I would lose capacity. And when Deputy Balash talked about removing people's choice, or actually, no, what he said is that a degrading death, that there's something degrading about being put to sleep, if you like, by a medical professional. It's not an ideal phrase to use, but being given an assisted death when it's something you already want, I don't see why that is degrading, and I think it's certainly no more degrading than perhaps being left to a slow, drawn-out and potentially painful death. Just because one's unconscious doesn't mean that one can't suffer. I think it's entirely possible. Who knows what happens in the unconscious or subconscious mind, sir, when one is in those final moments. Would I prefer to potentially drown in my own lungs rather than have an assisted death with somebody whom I've asked to be there to actually help me have that? I know which I think is more full of dignity. I think it's definitely the latter. But again, it's choice. The last part, and I'd also ask Deputy Curtis this question, is that where is the evidence that somebody has changed their mind? Because actually, there is no evidence to suggest that somebody who signed a waiver and who all throughout that last process has reaffirmed on several occasions, look, I do wish to have an assisted death in this particular scenario, there is no evidence that they've changed their mind at the last moment. In fact, we don't talk about the opposite scenario, do we? There will be people who change their mind at the last moment saying, actually, I do want an assisted death, but it's too late for them. So there will be lots of people in Jersey in the future suffering at the end of life who don't avail themselves of this service, of this right, of this that we're giving people, out of fear, simply because they may have been coerced out of an assisted death. We don't talk about coercion the other way, do we? But that is very much a possibility. There's a whole narrative in our society around coercion, around the taboo that there is about taking the final decision for yourself. And that's because we've got centuries of religion, I think, where we're told that actually it's not your life, you're lucky to be here, this is a gift. I do very much see life as a gift, but I don't see it as a gift that's been given by a conscious male deity. I think actually it's a miracle of the universe that we're all here against the odds. And so it's absolutely correct that we do value our lives, and part of that value is that we've all got a unique consciousness, a unique genetic and psychological makeup that makes us individuals. And for a piece of legislation, a small amendment today, to actually remove that ability for us to think for ourselves with absolutely no evidential basis to suggest that somebody's changed their mind whilst they're unconscious, I'm afraid it's just grasping at straws. It's a desperate last attempt, I think, for many who simply don't believe in the principle of assisted dying. And that's fine to not believe in it, but I think let's at least be consistent with the amendments that we're passing today, sir.
Thank you, Deputy Tadian. The next member to speak is the Minister for Treasury and Resources, Deputy Miller.
Thank you, sir. So first of all, I would like to object in the strongest terms to what Deputy Tadian just said. In particular, his rather, I found, threatening remark that he will be looking at the votes on this. This is a democratic process. We are all entitled, we are all here, whatever he thinks, we are here to express our views on this. We are all entitled to do that. And I strongly suggest if he thinks he's going to go out online and name and shame those of us who have voted contrary to his demands and his beliefs, then that is an entirely undemocratic thing to do.
Would the
I really
member
hope
give
that
way,
doesn't
sir?
happen. No. Sir, what I would like to say, this is a matter of conscience. We all have our own thoughts. It's all based on our own experiences, our own beliefs, and those beliefs may not be religious, they may be all manner of beliefs, whether you've got medical experience, what your own experience is. We are all entitled to our view. So the thing that has always probably concerned me most about this legislation is the question of capacity, and I will talk about that at a later date. Capacity can take very many forms, and I think I have struggled with, I wasn't intending, for those famous words, I wasn't intending to speak on this. But listening to the debate, I have decided I will, and I am going to support the Deputy's amendment. Capacity can take very many forms. Somebody could make a decision and then lose capacity. And that loss of capacity may mean that they have completely lost mental capacity. They can no longer speak, they can no longer make reasonable, rational decisions that anybody would accept as being fully informed. But they may be completely physically fit, and the doctor could come round to deliver the drugs that will end their lives, and find their patient sitting up, tucking into full English, full of the joys of life. What does the doctor do in that situation? That person may then have weeks left to live, or if not months. Capacity can mean that somebody has lost mental capacity, but their body is entirely self-sustaining. They could still eat, but they have a huge amount of pain relief. They may have lost consciousness, but their body may be still self-sustaining, and I say that they are not, their body is functioning, but they have lost consciousness, possibly because of extreme amounts of pain relief. And laterally, there are possibly people who have lost consciousness, who have lost capacity because of loss of consciousness, but they are, as words I have used before, being kept alive by a machine. And we know that in those situations, that death probably will follow in very close order, because the medical team will be discussing with the family to say, is this person dying? Yes, they're dying. Are they being kept alive by the machine? Yes, they're being kept alive. And the family and the medical team will make a decision as to whether to continue that care. So capacity takes very many forms, both mental and physical. And I do think this is a sensible amendment to introduce at this stage, that we can always reconsider at a future date when we see how the system plays out. Thank you, sir.
Thank you, Minister. The next member to speak is the Chair of the Review Panel, Deputy Dublin.
Thank you, sir. and I'm pleased to follow the previous speakers. I've listened with interest to the speeches and particularly the speech of the proposer, who I know has some strong convictions about this. And I really respect the depth of her feeling on this. And I feel that a lot of that is probably stemming from her former trade as a nurse. And again, I can really empathise with that as a former teacher. I think we don't stop embodying our professions, do we? And we carry those with us. That's something that I do as well. It's part of who we are. And I suspect perhaps were the deputy still in that profession, she would be amongst the numbers who might choose to not participate in such a service due to her conscience. And that is absolutely a right that is embedded. And just like the previous speaker said, that it is absolutely a matter of conscience. And my vice chair, I think, spoke briefly and eloquently about this as well, being a matter, I think, similar. For me, it's similar to the self-administration debate that we had, that this is very much a narrowing down of the principles and a matter of conscience and an ethical decision that must be made by each member on their own values and their own ethics today. So I'm going to speak about what the panel say in our report about the waiver, and then I will give some of my own conclusions. And in our report, so we haven't drawn a conclusion, a final conclusion for or against the waiver. Members must make this decision themselves. However, there is a lot of evidence in there, both against and for having a waiver. So I will outline what that evidence is to assist members with their decision making. And I think one of the previous speakers mentioned that more debate and clarification and scrutiny, I'm not sure who it was, said that. I'm absolutely confident, sir, that we have scrutinised this extremely thoroughly, as we have with the rest of the legislation. It's one of the areas that we gave most thought and consideration to, being one of those points that we can narrow down, those ethical points and safeguarding points. We spent a lot of time considering this, and as members will see, there are differing views on the panel, which again is always really valuable to me as a panel chair, to have those differing views and to be able to weigh up the evidence in that context. And so the panel's report does raise some concerns about the waiver, being the issue of contemporaneous consent and the fact that it wouldn't be a contemporaneous consent. And there are some ethical concerns around this, that capacity can be fluctuating, that there could be a potential increased risk of coercion. And another concern raised in the report was the willingness of practitioners to use the waiver and to operate in the service and use waivers. We have addressed many of these with our recommendations. Indeed, we have recommended that further targeted consultation be carried out. We're asking the Minister to conduct a new survey, a fresh survey, specifically focusing on this, to understand how many of the practitioners who are willing to be involved in the service are willing to operate with a waiver. And I think that this can reasonably be done by the Minister as the service is being set up, to establish the practicalities of it. We have also recommended that detailed and clear guidance is developed on how the waiver would operate in practice, and we're asking that this guidance is detailed. And I think some of the previous speeches have given examples of specific scenarios, and raising questions about what happens if this happens, what happens when. And that's why we're asking that the guidance be very detailed, so that medical practitioners can think through all of those scenarios as well. And we are also asking for specialised training in this area, so that administering practitioners can also consider the ethical and the clinical complexities. So that is the evidence that we have found against the waiver and the recommendations that we have made that would go a long way, I feel, to countering some of those downsides or ethical concerns that were raised in the report. And obviously the Minister is not compelled to respond formally to our report just yet, but I would really welcome if he were able to say of those recommendations that relate to the waiver, if he would be accepting those, because my feeling is that if he is able to accept all of those recommendations, that gives a strong argument in favour of keeping the waiver in the law, and that would give me more confidence in being able to support the use of the waiver. The panel also, Sir, we found evidence that was in favour of having a waiver facility, and the main point that we found was the autonomy principle, which of course is one of the foundational principles of this legislation. And again, many speeches focused on that with the self-administration. But this would protect the autonomy of the individual. And we also discussed at the public hearing the fact of the individual taking that responsibility as well for that decision that they make when they have full capacity, that at that point they are taking autonomous personal responsibility for that decision that they make. One of the previous speakers mentioned that they felt it was clinical and soulless, imagining somebody who was unbearably suffering but had lost capacity and had a waiver in place, imagining a doctor administering the drugs to them. And that struck a chord with me, because actually when I imagine that scenario, that to me feels like an act of deep compassion, and not an easy thing to do. It's not easy to be a doctor generally, I think. It's probably quite an emotional job, because you're dealing with life and death and people in great pain a lot of the time. And most of us don't have to deal with death in our day-to-day lives. But the practitioners who serve in our health service, they do deal with that most days. And I think that they do so and are motivated by compassion. And for me, sir, and I want to reflect on my humanist beliefs, compassion is a central element of humanism, and it's my own compassion and empathy for my fellow humans that drives much of my decision-making. And certainly, in the area of assisted dying, my beliefs as a humanist give me a deep conviction that assisted dying is the right thing to do. And turning to the point of the waiver, in my heart, I feel it is the right thing to do, because it is the compassionate thing to do. And I do feel it is ethical, having considered all of the evidence and considering our recommendations. I do think that it is the right thing to do. And I wanted to reflect on Deputy Renner's speech, because he made a point that I was going to speak about, which I won't repeat, but I just wanted to endorse, that ultimately not having the facility to sign a waiver will lead to people dying before they want to. And that, for me, was one of the ethical turning points that tipped the scales for me when I was considering this. Because there was a time when I was weighing up all the evidence, that I was still considering it. And that was one of the points that has helped me to decide. Because if we don't have the facility for a waiver, it will lead to people either suffering extreme pain and not accessing pain relief because they want to keep demonstrating their capacity, or they will end up dying sooner than they would otherwise want to, and I cannot accept that. And I wanted to finally, actually, for any members who are still perhaps on the fence, another turning point in my consideration of this issue was at our public hearing. And we gave a very rigorous treatment to this area, I think it's fair to say. And there was an officer there who was the chair of the End of Life Partnership Group. And he gave a really compelling point. And he said, I wonder if I maybe need to read the question. We were asking about if somebody was at the point where they had lost capacity and they were making a gesture that could be ambiguous and could be interpreted either way. We were trying to get to the bottom of what would happen and is it still the right thing to do to enact the waiver. This individual said, if I may just pick up your point about the risk that you're identifying that somebody could be put to death unable to communicate the decision that their choice had changed in that period. From my perspective, there would be a very fair assumption that if somebody had continued to clinically deteriorate to the point in which they could not speak and they lose capacity and that capacity does not return, that associated with that deteriorating function would be a deteriorating mental function. It would be very unlikely that they would maintain cognitive ability to be making a different decision in the context of their body failing and fading to the degree in which they could not verbalize or recognize around them what was happening. Our assumption here is saying that somebody would maintain the cognitive ability to change their mind despite losing capacity and the ability to communicate. From my perspective, if somebody was deteriorating to the point in which they could not talk to me, then there is a very strong assumption that they would not have the cognitive ability to be thinking about such a complicated topic and making a different decision by the default of how poorly they were in losing the capacity that they lacked. And that moment in the public hearing that was explained so clearly to us by somebody who obviously has the expertise and the clinical understanding of this area, I found that very compelling, and that was the evidence that helped me to make my final decision. And I hope that has assisted members in making their decision today, and I will not be supporting this amendment, sir.
Thank you, Chair. The next member to speak is the Constable of St Lawrence, and then after that I have the Constable of St John. So, Constable of St Lawrence.
Thank you, sir. And I'd like to ask a question, please, of the Attorney General, if I may.
Yes.
Thank you, sir. A little bit of preamble before the question, sir. I understand that the Isle of Man has already approved an assisted dying law, and it went to Privy Council many months ago. However, as I understand it, it has not yet been sanctioned, and I believe the reason for that is that the Ministry of Justice has asked a number of questions about it. I may be wrong, sir. I heard this on the radio this morning, so I am repeating something from the Today programme. Now, in her speech, Deputy Ward referred to a higher legal authority. I think she referred to that twice. She said this should be considered by a higher legal authority. It wasn't clear to me, sir, whether she was actually referring specifically to her amendment, and maybe she can respond when she sums up, or to the law as a whole. But what I would like to know from the Attorney General, sir, is whether or not the Ministry of Justice could be that higher legal authority. What I would like to know from him also is what jurisdiction, if any, does the Ministry of Justice have over our role as legislators? And if they have jurisdiction, why do they have it? And how could that jurisdiction impact on the entirety of this law? I think really, sir, can our law, when sent to Privy Council, or why can it be questioned by the Ministry of Justice, and what impact could that have on it, sir? Thank you.
Thank you, Conatop. Those questions were quite clear, I think, Mr. Acting Attorney. Would you like some minutes to reflect on your answers?
No, I'm happy to answer them now. The MOJ does not represent a higher legal authority. Jersey is autonomous in its domestic legislation. It is right that laws that are adopted in this assembly must receive the royal assent. It would be constitutionally entirely unusual for a democratically adopted law in this assembly to be declined assent by His Majesty in Council. I can only think of a circumstance where, for example, laws adopted in this legislation had a significant effect on the constitutional relationship between Jersey and the Crown, but that would not arise in the context of this draft law. So the higher legal authority may more likely be an ethical issue for members to grapple with, but it's not a legal issue, and it doesn't engage the Ministry of Justice. I hope that's helpful.
Thank you. Conatop?
Yes, thank you, sir. I've never heard before about a law being held up because of questions by the Ministry of Justice. And I'd just like to press the AG on it, sir. Can they, or could they, potentially question our law, if approved, when it is sent to Privy Council? And what could be the outcome?
Well, I think I've answered the question. I do not think it remotely likely that the Ministry of Justice would have any ability and would not constitutionally seek to interfere in a democratically adopted law in this assembly. I don't think I can take it any further.
So, could I...
I'm not sure who was first, but I think Deputy Taddia, you had your light on first.
I'm happy to give way. It's a question for the Attorney General, but it's a different question. So if there were questions relating to this area, and indeed if the Constable of St Lawrence wanted to finish a speech, because that was a question, then I'm happy to wait. So.
Yes, it was to continue questions to the Attorney General on this subject, but I don't know if the Constable of St Lawrence would prefer to speak, but I think there is more to be asked of the Attorney General in this area. So.
Very well. So, Constable, are you happy to speak?
I think that my questions have been answered, sir, although I am puzzled as to why the Ministry of Justice can question a law that has been approved by the Parliament in the Isle of Man, and yet they cannot do that if a law is approved by this legislature. But I'll wait to hear what the other members have to ask.
So are you happy to resume your speech?
I wasn't intending to make a speech, sir, other than just to address a comment earlier by Deputy Taddia. In principle, I do not support assisted dying. I recall, sir, when the minister who brought the original proposition to the Assembly told me that he was going to do it, it was because really he felt that no other minister at that time wanted to bring it forward, and he referred to it, sir, to me as state-sanctioned murder. And that has always been, that is something that I cannot forget, hearing him tell me, sir. And on ethical and moral grounds, I do not support it. So just to advise Deputy Tadje, when he does look at the voting record of all members, mine will be that I have not supported this at all. Thank you, sir.
Thank you, Conatop. The next member to speak was the Constable of St Lawrence, unless there were further questions.
I did have a question for the attorney, if that's okay at this juncture. Take advantage of the natural break in proceedings. So earlier in her speech, when she was moving this amendment, Deputy Barbara Ward, I think, suggested or even said quite strongly that she feared that without this amendment, doctors, medical practitioners could be liable to find themselves committing manslaughter, and I think she also said assisting unlawful suicide. It's something to that effect. Could the Attorney General clarify whether it is legally the case that what the Minister is proposing is likely to give rise to any liability or charges of those medical practitioners for either those charges or related charges?
Acting Attorney, would you like some minutes?
Yes. The fact is that the actions that the draft law enshrines are all, as matters presently stand, unlawful and would, if carried out, be likely to engage the criminal law. But that is the whole point of the draft legislation, which is to remove those activities from the realms of unlawfulness and the criminal law and to make them lawful. It follows from that if medical professionals engage in the processes that the law enshrines, and they do so in accordance with that law, they will not commit any offences. And that includes the provision for advanced waiver of capacity. These, it seems to me, are ethical and practical issues for the Assembly to grapple with, but they don't seem to me to be legal ones.
Deputy Moran.
Yes, sir. It's come to a question of the Attorney General, but taking the Attorney General back to the questions asked by the Constable of St Lawrence.
Very well. Do you want to ask your question?
Yes, thank you, sir. It's to ask the Attorney General, under what authority, or with this law or any draft law sent to the Privy Council for royal assent, would the Attorney General expect any department of the United Kingdom government to be able to ask questions about a draft law sent to the Privy Council for royal assent, and in asking such questions, potentially delaying the adoption of such a law? Would the Attorney General expect any department of the United Kingdom government to do such a thing, be able to do such a thing, and if so, under what authority are they doing such an act?
I'm just looking at the position in the Isle of Man because I've just received an email. Yes, the Ministry of Justice can ask questions about legislation, and they've asked questions about the Isle of Man. I understand that there has been dialogue with Jersey, and we've already have the answers to many of the questions which the Isle of Man have been asked. So the UK still does retain an overall responsibility for good governance in this island. I'm happy to say that we demonstrate repeatedly that we are perfectly capable of governing ourselves. I would be astonished if this law being adopted and I having signed a royal assent memorandum to the effect that it was deserving of royal assent, I would be astonished if it did not receive royal assent. If it didn't, we would be facing a constitutional difficulty of some magnitude.
Sir, I thank the Attorney General for his answer. The piece of information I'm really trying to get at is under what authority can the United Kingdom government ask such questions? Is it the United Kingdom government acting as the United Kingdom government, or is it a Secretary of State acting as for the King, for the monarch?
It's the Privy Council advising the Crown, and the Crown has a responsibility because the Crown, the King, is our head of state and our Duke, has a responsibility ultimately for the continuance of good governance in the island.
I thank the Attorney General for his question. So if my understanding is correct, it is tools that the monarch has at their disposal, which happen to be within the United Kingdom government, but it is not the United Kingdom government acting as the government of the United Kingdom.
That's correct. We enjoy a constitutional relationship with the Crown, which, like many British constitutional relationships, is unwritten. It is something of a ballet, and it requires all of us to avoid stepping on each other's toes.
Deputy Scott, question for the acting attorney.
Yes, thank you. So just one more question for, well, perhaps from me to the Attorney General, because if I understand this, that there's a strong constitutional convention that the UK will not interfere, but it could, if there's a clear breach of international law, if there's constitutional impropriety, or if there's a serious rights incompatibility. So I'm just wondering whether these discussions revolve around the interpretation of human rights law, where you've got two potentially conflicting human rights about the right to life, but also the right to liberty, and whether you know that's the issue here. But also to just confirm that this has been considered by law officers, of course, in the bringing of the law as usual.
Yes, the law's been considered in my department with great care. As for the Convention on Human Rights, I remember 2 years ago when the principle was first being debated, giving clear advice to the Assembly that the conflicting rights, the Article 1 right to life and the Article 8 right to private life, do not conflict. The European Court of Human Rights recognises what a difficult area this is. It gives a very, well, first of all, it doesn't say that any jurisdiction must have an assisted dying jurisdiction. It simply says if you do, it must contain sufficient safeguards that the Article 1 right to life is not impacted. And I have advised previously, and I advise again today, that this law entirely fits the bill in that regard, because it contains numerous safeguards, and I certainly have no concerns about that.
Very well, unless there are any further questions for the acting attorney, then I would ask the Constable of St John to speak.
So this continues to be a quality debate. So this continues to be a quality debate with good argument from both sides. I also recognise that this debate is probably the one that we have to use our own individual values more than any other, and I fully respect those with different views. So I don't have the level of experience of the Dean, probably not even 10%. I did, though, recognise some of the things he spoke about yesterday, including people seemingly waiting for loved ones to arrive. What I can say is that I have seen and experienced enough to make what I believe to be informed decisions. So I won't be supporting the amendment, and hopefully I will explain why. Sir, the waiver does not deny the right of a person to stop the process. The person must have capacity to make a waiver. They make their final request for an assisted death at the same time, when they do have capacity. The person must have a settled and enduring wish. If the person has capacity, they can stop the process despite the waiver. If the person has a waiver, the administrating practitioner will not proceed if there are any concerns about refusal. Waiver is not non-voluntary euthanasia. It is a voluntary decision made by people with capacity. So it is wrong to say that we have not consulted people. There was a specific question on the waiver in the Phase 2 consultation. And it's worth reminding ourselves, sir, that healthcare professionals have been involved throughout the development of the proposals and draft law. And like States members, sir, they will have different opinions, sir. In addition, UK professional regulatory bodies have continued to be engaged in developing the proposals and the draft law. We've been told by more than one person that another survey is required. I would remind members that surveys have already been carried out, and it's worth reminding ourselves that in one of the surveys, 19 doctors indicated that they'd be prepared to act as an assessing doctor. 51 professionals, doctors and nurses, indicated they would be prepared to act as administrating practitioners. 92 professionals, nurses, social workers, allied health professionals, indicated they would be prepared to be part of an extended team. 22 professionals indicated they would be prepared to act as pharmacy professionals. Sir, the panel chair reminded us about the report and the multiple recommendations, but importantly, it did not recommend removal. So I would agree with the chair that clear guidance and specialised training needs to be introduced, and I'm sure that this will be done. Finally, sir, the proposer spoke about suicide, and indeed I return to the Dean because in his contribution yesterday he asked about the difference between suicide and assisted dying. And I'd like to clarify to members what I believe to be the difference. Suicide is a lonely act, outside of a legal framework, accompanied by mental and physical pain and fear. Suicide invariably leaves behind a legacy of stigma and irresolvable grief for loved ones. Assisted dying can be the exact opposite, a safe, calm, and considered environment in which a person can end their life, most often with the support of their loved ones. Thank you, sir.
Thank you, Contab. The next member to speak is the Chief Minister.
This is not a procedural detail. It goes to the heart of how we balance autonomy with protection. The waiver as drafted would allow a person who has met all of the eligibility criteria and clearly expressed their wish to proceed to continue with assisted dying, even if they subsequently lose capacity before the final act. The amendment proposes that we remove that provision requiring that person retains full decision making capacity at every stage, including the point of administration. And there are strong arguments on both sides. On the one hand, removing the waiver strengthens safeguards. It ensures that consent is contemporaneous and beyond doubt. It reinforces public confidence that no assisted death could proceed without a person being fully aware and actively consenting at that moment. In legislation of this sensitivity, clarity, and protection carries great weight. On the other hand, we must acknowledge the practical consequences. Some individuals with terminal conditions experience rapid cognitive decline. Without a waiver, a person who qualified in every respect may lose access simply because their illness progresses. That raises a question about fairness, about dignity, and about whether we are unintentionally narrowing a compassionate choice. The debate is therefore not between care and indifference, it is between two legitimate principles: safeguarding the vulnerable and respecting previously expressed competent wishes. As legislators, our responsibility is to ensure that whatever framework we adopt is safe and legally robust and commands the public confidence, while remaining faithful to the fundamental aim of this law, to provide a carefully controlled option at the end of life to those who meet strict criteria. In my balanced judgment, and I urge members to consider not only the ethical principle they feel most strongly about, but also the practical operation of the law in real clinical settings. This is legislation that must work, works not only in theory, but in the lived experience of patients, families, and clinicians. In my balanced judgment, if Jersey is, and it is, early in implementing assisted dying, we tend to be politically cautious. And I think public confidence is important as we progress with this legislation. Then the advantages of this amendment slightly outweigh the disadvantage as a first phase safeguard. However, in a more mature assisted dying system, with strong oversight, again, which this law is proposing, and a tightly controlled waiver can be ethically defensible and more autonomy respecting, sir. Those are the choices we have to consider. I am undecided. I think I am leaning towards not supporting the amendment, but I'm still undecided, sir. Thank you.
Thank you, Chief Minister. Does anyone other member wish to speak in relation to the First Amendment? Minister for Health.
Thank you, sir. Having listened to a lot of very good speeches, I was tempted not to speak, sir, but I think I will, particularly I think I need to answer something that was mentioned by Deputy Bullock this morning. He referred to a question that I answered at a scrutiny hearing and didn't provide any context, which I think is very unfortunate. So what I'd like to do is refer to my printed speech, which covers a number of issues that have been raised by other people, but does cover off a number of other issues that I think are quite important. And I'll just mention the context about Deputy Bullock's comments towards the end, if that's right. So anyway, so in this instance, I'm speaking not to support the amendment, but to support retaining the waiver. This provision is not an add-on, nor a loophole, nor is it a dilution of any safeguards. It's an ethically grounded, carefully designed mechanism that protects autonomy, upholds the very principles this Assembly endorsed when it agreed the principles of the draft law, and it prevents people feeling forced to die earlier than they would without the waiver. It's designed to support terminally ill people who are suffering and approaching the end of life to have a greater control over the manner and the timing of their death, should they so choose. The waiver directly supports that principle. Without it, people who fear they may lose capacity in the final days of their illness face an agonising dilemma. Either they proceed with an assisted death earlier than they want to, while they still have capacity, or they risk losing the option altogether if their condition deteriorates, or they need more pain relief, and as a result, they lose capacity. We know from jurisdictions without a waiver that this isn't hypothetical. People with rapid neurological decline, or those receiving high levels of pain medication, can lose capacity within days or even hours. Practitioners in jurisdictions that do not permit the waiver have described situations where individuals have fought to live as long as possible, who are eligible for assisted dying, and have had a voluntary enduring wish, could not proceed because of the very recent loss of capacity. This distress, the distress that this causes to the individual, their loved ones, and the professionals involved can be profound. The panel's own expert advisors recognised this ethical reality when they wrote, there is arguably a strong ethical justification for having a waiver of future capacity. The waiver encourages people to live longer without losing their right to have the approved assisted death that they've chosen to arrange. This also promotes autonomy. And that's the key point, sir. The waiver allows people to live longer. The report accompanying the amendment claims that a waiver could lead to non-voluntary euthanasia. And I think we need to be very clear about this, sir. That claim is simply incorrect. The waiver does not allow anyone to make an assisted dying decision on behalf of another person. It does not allow a practitioner to override a person's individual wishes, and it does not bypass capacity requirements. A waiver can only be made by an individual who has capacity at step 6, after going through all of the eligibility assessments at steps 1 to 5, assessments undertaken independently by 2 doctors, each confirming that the person's capacity, the voluntariness of their wish, and their understanding. At step 6, the individual is again required to demonstrate capacity and to receive and understand detailed information from the administering practitioner on the implications of making a waiver. Only if that practitioner is satisfied that the individual has capacity and that their decision is voluntary can the waiver be made. Then at step 7, on the agreed date, the safeguards continue. If the individual still has capacity, the waiver is disregarded and they must make a new voluntary request for an assisted death. If they do not have capacity, the waiver may come into effect if and only if the person shows no signs of refusal or resistance. Furthermore, the administering practitioner may refuse to proceed for any reason, including any concerns about external pressure. And for all of this in the presence of a witness who must be a doctor, nurse, or assisted dying practitioner. To characterise this as non-voluntary euthanasia is both inaccurate and misleading. It remains a voluntary choice made with capacity and protected by legal, clinical, and procedural safeguards at every stage. Furthermore, I've lodged a clarifying amendment making it explicit that the decision at step 6 is a single decision, a final request including the waiver, so that there can be no misunderstanding. Every safeguard that could reasonably be put in place has been put in place. Sadly, sir, Deputy Ward's amendment report makes a number of statements that are inaccurate and create confusion. To be clear, nobody can make a best interest decision on behalf of an individual under the assisted dying law, and as per my clarifying amendment, this includes a person with lasting power of attorney. Nobody may make an advanced decision to have an assisted death. An advanced decision is a decision to refuse treatment, and assisted dying is not a treatment. A waiver does not bind a clinician to administer the approved drugs or support self-administration. They must refuse to administer if the person shows any sign of refusal. The draft law includes a specific capacity test which operates differently to the presumption of capacity as set out in Jersey's capacity and self-determination law. This is designed to reflect the magnitude of the assisted dying decision. As noted by the panel's expert advisors, an assumption of capacity under this assisted dying law can only be made if the doctor finds no evidence of lack of capacity whilst making their assessment. Any assumption of capacity is post-assessment, not pre-assessment. The waiver is not a late addition or an untested idea, nor was there any failure to openly discuss it during the policy development process. Indeed, the concept of the waiver emerged from detailed consultation with assisted dying practitioners, public feedback, and engagement with UK professional regulatory bodies. So it's also worth noting that in the phase 2 consultation, 83% of the respondents who supported assisted dying also supported the waiver. And importantly, UK regulators, the GMC and NMC, raised no concerns. They've confirmed that the waiver, as drafted, is not inconsistent with professional guidance. So the question before us is not about weakening safeguards or changing the principles of the law. It's about whether we allow individuals who are eligible, who are suffering, and who have made a clear, voluntary and informed choice to have that choice respected, even if their illness takes away their capacity at the very end. So retaining the waiver promotes autonomy by enabling people to live longer without losing their chosen option, prevents avoidable suffering for individuals, families and practitioners, and is safeguarded at every stage, and it reflects feedback from extensive engagement and consultation, and it reflects the Assembly's own previous decisions. The waiver does not undermine the draft law, it completes it. And so it's against that background that I believe, I haven't got a transcript of the discussion to which Deputy Balash refers, but I can only imagine that the comment I made saying that I was comfortable was in relation to assisted dying being applied under these circumstances and in relation to the waiver. And I think that's a very, very different situation than that which Deputy Balash sought to infer in his comments. On that basis, I urge members to reject this amendment. Thank you, sir.
Thank you, Minister. The next member to speak is the Minister for External Relations, Deputy Gorst.
Thank you, sir. It's tempting to start by going down the constitutional rabbit hole that one or two members set hairs running down. It isn't, of course, unusual, nor to be unexpected, that those who have to provide files for Privy Council ask questions so that those questions can rightly be answered, and my department, together with the law officers department, sits at the forefront of ensuring that any questions that might arise before submissions are made to Privy Council are appropriately answered, and we do. And I think that Jersey can be proud of its record on good governance and government. And we often I think, in this place don't recognise that. And for my part, sir, it would be highly ironic for the United Kingdom government to suggest anything other than we did have good governance and good government. But let's not, as I say, go down that particular rabbit hole. We are reminded that this is a piece of legislation about life and death. And whilst Deputy Tadia might believe that we are here by accident, or I think in his term, against all the odds, I don't. I don't see any evidence for that belief at all. I believe that life is, and I think he did say it was a gift, and that life is precious, and we should consider it as so. And at the same time, of course, there are many good arguments on both sides of this argument around the introduction of assisted dying more broadly, but also around the waiver. And I've been sat here this morning for the last, 2.5 hours, of course, listening very carefully to what colleagues have been saying, as is the job of a legislature. But in the back of my mind has been those 990 islanders who die every year, to whom access to this law rightly isn't available. If we look at the department's figures, they suggest that anywhere between 7 and 10, I think it is, if we're being generous, it might get up to 20 islanders may be able to avail themselves of this form of assisted death in any given calendar year. We know from the statistics unit that roughly 1,000 islanders die every year. And although we are rightly scrutinising this legislation, I think the most important decision that this Assembly made in regard to life and death was one that it made in January of this year, where the commitment was given by the Minister for Health and Social Services to ensure that there was appropriate end-of-life care for all islanders. And that work, I think, is the most important piece of work that the department will be undertaking. And it will be tough work, because if we in this Assembly, on either side of the argument, truly believe in every islander having the best possible death, it is that work which will deliver the best possible death for every islander. Because we all know, in all of our conversations with islanders, there are far too many islanders now who don't have that, what some might describe as a right, afforded to them. And that is an issue which I know and I hope the department is prioritising. So the question then comes down to, this is a life and death issue. Are there sufficient safeguards in place? It's safeguards which it goes hand in hand in regard to this amendment with capacity. For some, we have heard throughout the debate on the amendments that they believe that there are sufficient safeguards. I don't think, unless we are 100% certain that there are sufficient safeguards, then the safeguards can't be sufficient. It stands to reason. A 1% potential for error means that someone may lose their life. If the safeguards aren't 100% foolproof, then the unintended consequence of that may mean that a life is lost. And that, for me, is a cost too far. But then we come to capacity and the waiver. What we are saying by maintaining the waiver is that an islander can have capacity to make the decision to avail themselves of assisted dying, and they can then sign a waiver, which of course they'll have to have capacity for, to say that when they lose capacity, they wish to be treated as if they had capacity. But if capacity is so critically important to the overall functioning of this piece of legislation, and I believe it is, if one believes that the freedom of choice is so fundamentally important that we are going to change the nature of life and death in our community, then capacity, and capacity at all times to make that decision or to change one's mind, must be fundamental. Because by the waiver removes, ultimately, if capacity is lost, the ability to change one's mind. And it is important, the ability to change one's mind. We all have brought to this debate personal stories, but we all know throughout life and throughout illnesses, one's mind can be changed. And for me, that's the fundamental point about the waiver. You are in advance, and for some members, as the Chief Minister said, that might be appropriate. You are in advance signing a waiver to say that you will no longer have the ability to change your mind if you lose capacity. But you will have lost capacity. The foundations of this legislation are that you have capacity to be able to make an autonomous choice. And therefore, for my part, sir, I think that Deputy Barbara Ward is absolutely right to raise this issue, because it's an issue about safeguarding and it's an issue about capacity. And when I consider those two fundamental parts of the legislation, I can only arrive at the conclusion that the waiver, it doesn't remove a safeguard, as some members have said, but what it does is remove capacity and therefore ultimately the ability to change one's mind, and therefore I support the amendment. Thank you, sir.
Thank you, Minister. The next member to speak is Deputy Howell.
Thank you, sir. My speech is very much along the lines of Deputy Gorst. In the news on Radio 4 this morning at 5:30 and then half-hourly, it stated, Jersey is set to become the second Crown dependency to agree assisted dying service. It confirmed that the proposed law is to be based on an individual having capacity to make a decision. So that is capacity at all times. That is the basis of which we agreed as an assembly for this assisted dying law. And I do not think even if an individual has expressed a wish to end their life, if they have slipped into unconsciousness, they do not at that time have the opportunity to change their minds and say no at the final moment. This would not be the withholding of life-sustaining treatment or giving medicine to alleviate pain or suffering. This would be the administration of a drug, and somebody would then die. It would, I think, place an administering doctor or practitioner in a very difficult position. And I say, sir, that we cannot allow this to be part of the proposed law, because the proposed law says you have to have capacity at all times. And I urge you to please vote for Deputy Barbara Ward's amendment and oppose this waiver. Thank you, sir.
Thank you, Deputy Howell. Does any other member wish... Constable of St Mary.
Thank you, sir. I wasn't originally going to speak, but the last two speeches have made me concentrate on this whole question of capacity. And I think we need to look at it in a more general sense. I fairly recently witnessed two friends of mine signing and enjoying power of attorney to cover the situation when they would have dementia and would no longer have the capacity. They recognise that is coming down the line. They wish to make that decision now whilst they had capacity. I've also, in my legal career, had situations where someone could not sign a will, which I prepared because they'd had an accident in due time and not have the capacity. And there are other instances too. Surely, so the basic position is that if you make a decision when you have capacity, when you lose it, your last decision stands. You're no longer capable of making a different decision. As I see it in simplest of terms, this is what the original proposition, so not Deputy Ward's proposition, but the original proposition says. And I think, in a way, we would be denying patients their established wish if the right of waiver was removed. I am therefore firmly of the view that, in a more general sense, it will be very much a backward step if the right of waiver was removed, and I therefore shall not be supporting the amendment.
Thank you, Conrad Harp. Does any other member wish to speak on the first? Minister.
As much as I've spoken, I failed to address a question from the Chair of Scrutiny with regards...
Well, I think you've had your speech, Minister.
Sorry, I just wanted to say that I'd happily go along with what was requested.
You've had your speech. Does anyone other member wish to speak on the Minister for Planning and Environment?
Thank you, sir. So whether you're a member who's been in the House only for this session or one who's been much longer, this will be an important debate, and that doesn't get anywhere near to the importance of it. This amendment in particular, I feel, always was going to be a significant point in this debate. Members will know I've always been a supporter of assisted dying, but nevertheless I've spoken to Deputy Barbara Ward about this amendment, and I promised her that I would listen to everything she said, and I've done that. But I've also listened to other members during the course of this debate, particularly Deputy Rob Ward, Deputy Reniff, and most particularly Sir Deputy Doublé, who finished up by making some very significant points on capacity and the people's ability to have the capacity to change a decision as their mental and physical health deteriorates. I don't want to demean the debate, sir, by speaking about something which is less significant or less important, but I do want to mention 3 letters to members, and that is DNR, do not resuscitate. And I think we have here a certain amount of precedent which we can look at for some reference. It's a voluntary decision, usually made by the patient in consultation with the family, the doctor, or a legal proxy. But sir, it's a legally binding order, a medical document signed by a doctor instructing healthcare providers not to perform CPR. Ensures that someone who is terminally ill will not be subjected to invasive, often unsuccessful revival attempts. And the reason I make the point is many of us will know that sometimes we make decisions to do something, but sometimes we make decisions not to do something. And what I say to members is not doing something is just as much of a decision as actually doing it. And in DNR, do not resuscitate, we are making a conscious decision to not do something because of the will of the patient, the person, a decision they have made previously, and they would be in that situation not capable of communicating. And we follow their instructions through. And for me, this debate, this amendment is exactly the same. People have made a decision while they had capacity, and when they no longer have capacity, we follow through their instructions. I've listened to everybody, but I will not be supporting this amendment, sir.
Thank you, Minister. Does any other member wish to speak on the first amendment? If no other member wishes to speak, then I call upon Deputy Barbara Ward to reply.
Thank you, sir, and thank you, members. I think the fact that we have gone on for over 2 hours debating this, I think shows that it's been very, very important to, in some ways, clear the air and for people to express their feelings. I've been making notes of what people have actually said, and if I read out everything, all the comments, we're going to be here till way after lunchtime. So I won't do that, members. I'm very pleased and thankful to the Attorney General for his views. And that in some ways it's about the higher legal authority, which was asked and what I alluded to. I think at the end of the day, Deputy Gorse raised the issue. It is about capacity and the ability to change one's mind. Please never, ever forget that. And that is across the board. It's not to do about assisted dying or anything else. We have the right as human beings to change our mind. But if you're asleep or you have lost capacity, you do not, sir, have that ability to change your mind. I don't have all the answers, and I'm pleased that I actually raised this issue. And I still feel that the assisted dying law should not have the inclusion of the waiver. I remain that it is unsafe. It opens up mixed messages. There is a possibility of coercion, especially in its subtle relation forms. It will require multidisciplinary expertise that can't be delivered through a medical assessment alone. Decision-making capacity requires enhanced safeguards and clearer guidance, which we need, particularly in relation to this waiver. But also islanders have not been consulted or voted on having something to know exactly what it's about, what this assisted dying is about. I'm very pleased, as I alluded to the Deputy, about the Assisted Dying Review Panel report commissioned by the Health Scrutiny Panel. And it states on pages 34 to 38 in relation to the waiver about future capacity, which very much echoes my concerns around the waiver. And I'm very pleased for that information. And they have set out key findings, numbers 10 to 15. But if we look at number 11, the serious concerns that exist about the risks and ethical complexities of the waiver for future capacity. We must be mindful of that, sir, everyone. If Jersey wishes to ignore or vote against my amendment, and the draft law continues as is and includes this waiver, I'm very worried as to where this waiver clause will be further developed going forward for patients that don't have a terminal illness, or people suffering, for example, people who are suffering from dementia, stroke patients, a severe head injury. People sometimes actually do come round. They do come round. But who knows? That's for the future. To support the basic principle of assisted dying law to go forward and be in keeping with many jurisdictions, especially the UK and our Crown dependencies, then any reference to the waiver really does need to be removed. And just to be clear about the Isle of Man, it's been waiting 11 months for royal assent. It's still being considered. It hasn't received royal assent. It is still under consideration, to my best belief, sir. So we need to be focusing on the living and try and improve our existing health services. I want to thank everyone again for the debate and for listening. I hope my presentation may have persuaded some of you to support my amendment and have the waiver and related article elements removed from the draft law so we can move on and get this assisted dying law as amended, voted in and going forward. That is so that it is clear and more transparent, where people can make a fully cognizant decision to self-administer the terminal solution and fulfill their final wish to die. Thank you very much, sir, and members, and may I ask for the appel? Thank you.
The appel is called for. I invite members to return to their seats. All members had the opportunity of returning to their seats. I ask the greffier to open the voting. If all members have now cast their votes, then I ask the greffier to close the voting. And I can announce that the proposition for the First Amendment has been defeated. 19 votes pour, 29 votes contre, and no abstentions.
Unsurprisingly, sir, I'll ask for the 19. Thank you.
Those members voting pour, the Conotava, St Helier, St Brelard, Trinity, St Peter, St Juan, and St Saviour, and Deputies Morell, Lehegara, Gorst, Moore, Balash, War, Catherine Curtis, Miller, Howe, Berry, Kovac, Barbara Ward, and Wilson.
Very well. We move on to vote 6 according to the running order, and this relates to the section E of the Second Amendment lodged by the Minister. I remind members that the Third Amendment was defeated, so therefore the highlighted text in the running order relating to Article 8 is now included in this amendment. So now I would invite the greffier to read section E of the Second Amendment.
Page 143, Article 8. For Article 8.4 substitute, the individual's care plan must record their preferences for their assisted death, including A, when and in which place it will be done, B, who will administer approved drugs to them, whether the individual themselves or a practitioner, and C, how the approved drugs will be administered, such as swallowing or injection. Page 144, Article 9, 1, delete Article 9.1F2, and 2, renumber Article 9.1F3 accordingly. And page 161, Article 36, 1, in Article 36.1, delete unless an exception applies, and 2, in Article 36.1, in the table, delete the third column.
Thank you. I call upon the Minister to propose section E of the Second Amendment.
Sir, the draft law provides all health and care professionals very clear rights to refuse to participate in assisted dying. This includes professionals who've chosen to work as an assisted dying practitioner but wish to practice in specific circumstances only. For example, the draft law provides that an administrating practitioner can choose to support self-administration, i.e. they can refuse to administer the approved drugs to the individual. However, the draft law goes on to state that if an administering practitioner previously agreed to administer the approved drugs as part of an individual's care plan, they cannot then change their mind. Following feedback received, I seek to amend this provision to allow an administrating practitioner to refuse to administer the approved drugs in any circumstances, even if they previously agreed to do so. An administration witness may also refuse to witness the practitioner administering the drugs. So this part of my amendment aligns with the proposals agreed in P18/2024 and upholds the right of the professional to choose if and how they participate. Clearly, if an administrating practitioner was to refuse to administer the drugs and the person was not able to self-administer, arrangements would have to be made for an alternative administering practitioner to act. And this would be done as part of the standard operational practice. I would just add that that operational practice would have to have something ready to go in very, very short order, and that would be the intention. So I commend this amendment to the Assembly, and I hope that members will back it, sir. Thank you.
Thank you, Minister. Is Section E of the second amendment seconded? Thank you. Does any member wish to speak on Section E of the second amendment? Deputy Dublet.
Thank you, sir. Very briefly, the panel are in support of this amendment and thank the Minister for making it.
Minister, does anyone other member wish to speak on Section E of the second amendment? Minister, do you wish to reply?
No, sir.
Would those members in favour of Section E of the second? Appel is called for. If all members have had the opportunity of returning to their seats, I would ask the greffier to open the voting. All members have had the opportunity of casting their votes. I would ask the greffier to close the voting. And I can announce that Section E of the second amendment has been adopted. 43 votes for, 1 vote contra, and no abstentions.
Can we have the one, please?
The Connétable St Lawrence voted contre.
Very well, we move on to Section D of the second amendment, which is proposed by the Minister for Health. I would ask the greffier to read Section D of the second amendment.
Page 143, Article 8. In Article 8.5, for make their final request for assisted dying and propose to waive, there is substituted propose to make their final request for assisted dying and waive. In Article 8.6a1, after final request for assisted dying, there is inserted, including to waive the requirement for future capacity. In Article 8.6a2, after final request, there is inserted, including to waive the requirement for future capacity. Page 153, Article 23. For Article 23(1)(c), there is substituted, C, an administering practitioner at Step 6 in deciding whether they are satisfied that an individual has capacity to make the final request for assisted dying, including to waive the requirement for future capacity, or D, an administering practitioner at Step 7 in deciding whether they are satisfied that an individual has capacity to make the final request for assisted dying. Page 155, Article 26. For Article 26(1)(c), there is substituted, C, at Step 6, to decide that they are satisfied, under Article 8.6a, that an individual has capacity to make a final request for assisted dying, including to waive the requirement for future capacity, or D, at Step 7, to decide that they are satisfied, under Article 9.2a, that an individual has capacity to make a final request for assisted dying. Page 155, Article 27. 1. In Article 27(1)(b), after final request for assisted dying, there is inserted, including to waive the requirement for future capacity if at Step 6. 2. For Article 27(6), there is substituted, 6. An administering practitioner must comply with paragraph 7 A, at step 6, to form a reasonable belief under Article 86A that the individual's final request, including to waive the requirement for future capacity, is voluntary, or B, at step 7, to form a reasonable belief under Article 9.2b that the individual's final request is voluntary. Page 165, Article 42. For Article 42.2d, there is substituted D, whether the individual's final request for assisted dying, including to waive the requirement for future capacity, meets the requirements in Article 86A at step 6 relating to the individual's capacity and whether the request is voluntary, and E, whether the individual's final request for assisted dying meets the requirements in Article 9.2a and b at step 7 relating to the individual's capacity and whether the request is voluntary. 2, renumber existing Article 42e and cross-references accordingly.
Thank you, Greffier. I would ask the Minister for Health and Social Services to propose Section D of the Second Amendment.
Sir, we've just debated Deputy Ward's amendment and determined that the draft law should provide for a person to make their final request for an assisted death at step 6, including waiving the requirement for future capacity. So we now turn to the part of my amendment that touches on this issue. In reviewing the draft law, the panel's expert advisors made a number of comments which indicate that it is not sufficiently clear on the face of the draft law that if an individual chooses to make their final request for assisted dying and chooses to waive the requirement for future capacity at step 6, they are making a single composite decision, i.e. they are deciding to make their final request for assisted dying, including waiving the requirement for future capacity. So this is logical and accords with the policy intent, because the final request that's made at step 6 has no practical function without a waiver, and vice versa. Clarifying the fact that a single decision is made puts beyond doubt the requirement for the administrating practitioner to be satisfied that the individual has capacity to make their final request for an assisted death at step 6, including waiving future capacity. So once again, this part of my amendment doesn't alter policy or interfere with the principles of the draft law. It only amends the drafting, ensuring that in relation to this very specific matter, the law is clearer and better understood. On that basis, sir, I ask members to support the proposal. Thank you.
Thank you, Minister. Is Section D of the Second Amendment seconded? Yes, sir. Thank you. Does any member wish to speak on Section D of the Second Amendment? Deputy Dublé.
I wish to thank the Minister and also our advisors, because this was a quite fine point of detail that they picked up on. And again, we're very grateful for the advisors' input and for the Minister and his officers taking that on board and making the amendment, and the panel supports this.
Does any other member wish to speak? No other member wishes to speak. Would members in favour of adopting Hello's called for? If all members have had the opportunity to return to their seats, I ask the greffier to open the voting. If all members have had the opportunity of voting, I ask the greffier to close the voting. This part of the Second Amendment has been adopted. 41 votes pour, 2 votes contre, and 1 abstention.
Those members voting contre, the Connétable of St Lawrence and St Saviour, and Deputy Morell abstained.
Thank you. We now move on to point 8 of the running order, and I would ask the greffier to read the 4th amendment.
Page 143, Article 8. Delete Article 8.8 and renumber Article 8.9 in cross-references accordingly. Page 144, Article 9. Delete Article 9.1.1 and renumber Article 9. Delete Article 9.1i and renumber Article 9.1j and k in cross-references accordingly. Page 165, Article 42. For Article 42.1a substitute, A, if they are an individual appealing against a decision specified in paragraph 2. delete Article 42.3 and 7 and renumber Article 42.4 to 6 and cross-references accordingly. And to page 190, Article 98, delete Article 98C.
Thank you. I would ask the chair of the review panel to propose the fourth amendment.
Thank you, sir. This is the second of our, I think, 7 amendments, and the second that the Minister is not accepting. And I do understand some of the reasons why, but I will outline the reasons that the panel have brought this amendment to the Assembly today, sir. So the effect of this amendment would be to remove provisions which would allow third-party appeals by those with a special interest against a positive eligibility decision. And in plain terms, that means if somebody who is perhaps a close relative, partner of somebody who has had an approval to access the assisted dying service, if that person who is close to the patient disagrees with that positive decision that they can access it, they can access the court system to appeal that decision and try to stop that person accessing the assisted dying service. And again, the panel gave this great consideration, and one of the things that we did was we looked for international comparisons, and we did find an example. The only examples we could find were in Australasia, and Queensland was one of the places that does have this. Even there, it hasn't actually been used. So one of the arguments against having this mechanism is that actually it's not necessary and not something that would be used. The UK's Terminally Ill Adults Bill contains no third-party appeal rights. So if we were to introduce this, we would be somewhat of an outlier. And the panel feels that it would be best to not include such a provision. Another point against having a third-party appeal mechanism is around autonomy and human rights, sir. And we examined the potential for conflict with people's right to autonomy and private life under Article 8 of the ECHR. The human rights analysis to the draft law doesn't actually address this, but our advisors did warn us that it could potentially be incompatible with this article. And the panel felt on balance that decisions about end of life should remain with the individual themselves and not with others. We also had some concerns around confidentiality of medical information and the fact that a third-party appeal process could actually force disclosure of sensitive medical information to people outside of any clinical pathways, which could potentially be embarrassing or distressing to the patient who has requested to use the assisted dying service. The definition of special interest we also felt was potentially quite broad, and the risks associated with allowing this third-party appeal mechanism would mean potential delays to the assisted dying process where a person with capacity has been approved to access the service. They could be subjected to delays. There could be adversarial disputes. It could interrupt clinical care plans and result in much conflict, and it just does not seem to be in the interests of patients and creates a lot of uncertainty. We also felt that it could potentially actually be used to coerce somebody into not even requesting assisted dying, because if a patient was in a position where they were a victim of emotional abuse and they were being subjected to coercion, the potential threat of a third-party appeal by this person who is their abuser, and the worry that that might be used as a tool, that could be very, very concerning for that individual and could actually cause them not to request the use of the assisted dying service in the first place. When we looked at this as a potential safeguard, we found that actually across the board, the panel felt that the existing safeguards were already robust and that this would be an unnecessary step, and that the existing independent medical assessments, capacity assessments, the coercion checks and the training, especially with our amendments and our recommendations, we felt that there was enough tightening up of the safeguards that this was not necessary when balanced with all of the downsides that we've identified to it. So, Sir, the panel asks that members consider this, consider the evidence presented in the report to the amendments and in our review report, and make a decision about whether third-party appeals should be included in our legislation or not.
Thank you, Deputy Dublé. Is the fourth amendment seconded?
Yes, sir.
Thank you. Does any member wish to speak on the fourth amendment? Minister for Health was marginally first.
The Minister of Health has allowed me to go first. In fact, I just wanted to ask a question of the Attorney General, sir.
Very well.
If I may. Because when I have looked at this amendment and indeed the comments, it's saying that an appeal may be made on the grounds that the decision was not made in accordance with the law, or if the decision was unreasonable or irrational. So basically it was incorrect. And says a person with special interest cannot appeal on the basis that they disagree with the individual's decision to seek an assisted death. So in my mind, this seems to be formalising or doing something along the lines of a judicial review. And my question to the Attorney General is, because this is basically challenging an administrative decision, saying it was, no, you've agreed to an assisted death. And so I see this as a safeguard, potential safeguard, that somebody basically, somebody's assisted death is going to take place, and it's not in accordance with the law at all. And typically, you could have judicial review for this, and it could be a slower procedure. So my question to the Attorney General is, how does this actually differ from that? Why would this, create something that might be preferable, just so that we can have some clarity here, please?
Mr. Acting Attorney.
Yes. I think the question around judicial review is whether this is a public law matter. And I, for my part, am very doubtful that it could properly be called that. The decision to have an assisted death is an intensely personal matter, and that's why I'm doubtful that judicial review would be available in this instance. Judicial review might be available in terms of wider public law matters about the provision of the service generally, and those sorts of issues. But this strikes me as probably being not susceptible to JR, which is why this third-party right may be there.
Thank you.
So could I ask a
question? Yes.
So the question I've got, and I think may be helpful for all of us to understand, is that what the Minister's proposing in terms of a third-party appeal effectively here is whether that could be used in any way vexatiously by a third party to try and prevent somebody who's made a settled decision to have an assisted death, and effectively to time out that person's decision, so that could he answer either of those two questions?
Mr. Acting Attorney.
Well, one can never rule out the possible existence of vexatious litigants, but the court process is designed in this instance to be robust. It's robust as to timing. There is a very tight timetable for bringing and dealing with an appeal, a third-party appeal, and the tests that the law sets for a successful appeal are high. In respect of the health criteria, it would have to be established that the decision that a person did meet the health criteria was irrational, that is to say, not based on reason, logic, or judgment. That is a very high hurdle indeed for any appellant to surmount. And then in respect of anything else, that the decision was unreasonable, that's to say a decision that no reasonable person could have made, which I know is circular, but that's the way the law speaks about it, or was not made in accordance with this law. It may be helpful just to point out that the third-party right of appeal only arises at one stage of the process, which is where a positive decision has been taken by a medical practitioner to allow an individual to proceed from step 5, which is the second and final request for assisted death, into what one might call the terminal stages 6 and 7, where the arrangements for the death and the carrying out of it take place. It's only at that stage that the third-party right of appeal arises, and so it's limited in its temporal application as well.
Thank you. Yes, and the appeals provision is set out in Article 42 of the draft law.
Sir, could I also ask a question of the SG while he's...
Yes, Minister.
I understand from what the SG has just said is that the bar for making such an appeal is a high bar. If we were to accept this amendment and a third party became aware of an unlawful use of, or somebody in a situation where there was coercion or the processes and practices weren't being followed correctly, would the third party have any other form of raising an appeal if we accept this amendment?
Acting Attorney?
Yes, not in the formal legal sense of bringing a legal appeal to a court or a tribunal. I'm just looking at Article 61, paragraph A, subparagraph 2 of the draft law, which provides this, and it's talking about the Assisted Dying Committee that is going to be established by law. The committee must arrange for the service, that's the Assisted Dying Service, or another supplier, to develop or amend the following information, and 2, standards for services in relation to assisted dying and procedures for investigating and resolving complaints about the services that they or others have received. I'm then looking at the report to the proposition at page 114, paragraph 53, where this is said, in the event of safety concerns, the assisted dying complaints policy will set out the procedures for responding to concerns, both in terms of HCS processes and any escalation to the JCC or the relevant UK professional regulatory body in the instance of fitness to practice concerns. And at paragraph 72, the Assisted Dying Assurance and Delivery Committee will publish an assisted dying complaints policy, setting out a clear process for complaints and concerns by service users or their family and other professionals. They will also monitor compliance against that policy. Well, now, complaints made under those sorts of arrangements may be preemptive. They may be made ex post facto. The point about the third-party appeal mechanism, it allows for a preemptive challenge. The only other avenue that might be available, and very much if I can call it that nuclear option, if there were suspicions that a practitioner was acting out with the law, then the option of reporting that suspicion to the police would be there, because there might be suspicions that a crime was either going to be committed, was in the course of commission, or had been committed.
So, may I ask a question of the AG?
Yes.
I don't know if this is something you can answer, but I'll give it a go. So is there a legal definition of special interests? Because it says a family member and professional. I just wonder if that professional has to be directly linked with the medical profession. And what about circumstances? I just wonder if there is a legal definition of special interest that we can talk about. Thank you, sir.
No, not yet there isn't, although if enough cases did come to court through a third-party appeal mechanism, one could see a body of case law building up. But I'm looking at Article 42, paragraph 7 of the draft law, and it says this, in this article, quote, person with a special interest means a person whom the court is satisfied has a special interest in a particular individual's care and treatment, such as, so permissive, not prescriptive, such as certain connected people or professionals involved in the individual's assisted dying process. So at this stage, it's going to be a matter for the court ultimately, and it remains to be seen what shape that deliberation would take.
If I may follow up on that, just quickly.
Yes.
And so therefore, if we do have a third-party appeal system, could there be appeals around who has a special interest? I.e., would that have to be defined? So if I was somebody who was a friend of somebody and I said, well, I have a special interest for a number of significant reasons, would I be able to appeal the special interest before a process of appealing the assisted dying happens? I.e., could we get ourselves into lengthy court proceedings over what a special interest is without a definition available? Thanks, sir. I hope that makes sense.
It does make perfect sense, and it's a very good question. The answer is no. Article 42, which is the third-party, it's appeals, but includes the third-party appeal provision, says this at paragraph 4. The Royal Court must determine the appeal as quickly as reasonably practicable, and in doing so may affirm the decision, cancel the decision, decide the matter itself, require the decision maker or another person to reconsider the matter and make a new decision. And then at paragraph 5, there is no further right of appeal. So if you sought to argue you were an interested person, special person with a special interest, forgive me, and the court decided you were not, that would be the end of it.
Unless there are any further questions for the attorney? No. Then, Minister, you wish to speak in relation to this amendment?
Sir, yet again, much of what needs to be said has been said, and I thank the Attorney General for being so comprehensive. Nonetheless, there are a number of different points that I think I should just cover, just for the sake of completeness, sir. Firstly, sir, I think we need to be mindful of exactly what third-party appeals actually do, and more importantly, what they don't do. So a person with a special interest may appeal only on very limited grounds. That the decision to approve was not made in accordance with the law. For example, that the steps in the process were not carried out or were carried out incorrectly, or that the decision was unreasonable or irrational, and by way of example, it would be irrational for a doctor to estimate life expectancy of less than 6 months, when in reality it's a lot longer than that, sir. Crucially, and this seems to be a point of confusion, they cannot appeal on the basis that they disagree with or are distressed by the individual's choice. So this is not a veto, and describing it as such would be completely inaccurate. Instead, it's a narrow legal mechanism allowing a challenge only when something appears to have gone wrong with the decision-making process. And I think that's the crucial point, sir. Second, third-party appeals are part of a much wider framework of safeguards that have been shaped through extensive consultation and ethical scrutiny. Public feedback during phase 2 of the consultation was very clear. 63% of all respondents supported third-party appeals, increasing to 80% among those who were strongly in support of the principles of assisted dying. And this tells us something quite important. Even those most committed to assisted dying see the value of this safeguard. They want a system that is careful, credible and safe, and even if that were to result in the court overturning an assisted dying approval. And as we've already heard, this is something that's likely to be used very, very seldom. The 2023 ethical review authors also recognised that value. They examined the question of appeals in depth, including the right to have a third-party appeal, and concluded that they would strengthen public confidence. They said that whilst appeals would prolong the assisted dying process, the delay is proportionate to the safeguards gained. The Assembly itself, in adopting P18 2024, has already endorsed the model of assisted dying, which includes third-party appeals. Third, and as mentioned by the chair of the scrutiny panel, we must consider human rights, particularly Article 8, the right to a private life. Whilst the inclusion of third-party appeals may interfere with that right and the associated autonomy to make decisions, the interference is very limited. And certainly, I'm certainly satisfied that based on the evidence received, that the interference is both proportionate and justified. The draft law contains provisions that work to ensure third-party appeals cannot be misused to undermine a person's dignity, choice or privacy. These protections include appeals cannot be made by campaigning organisations or others who do not have a legitimate interest in the care or treatment of the individual, and a third party may only appeal on very limited grounds. They cannot appeal simply because they disagree with the individual's choice. And the law requires the court to determine the appeal as quickly and reasonably as they possibly can. Concerns about confidentiality being raised by the panel's expert advisors, and these are understandable, but they're addressed within the draft law. Article 41 permits disclosure only where necessary for an appeal. Article 98 provides the rules of court that will govern how such information is handled, and the Royal Court's inherent jurisdiction already allows it to manage sensitive information with care and discretion. This is not uncharted territory, sir. Finally, while it's true that third-party appeals are not common internationally, that's no reason in itself to exclude them. Jersey's chosen a model with strong layered safeguards. We should not allow those protections simply to mirror other jurisdictions. Our responsibility is to design the right system for Jersey, one that balances autonomy with protection, compassion and certainty, and individual choice with public assurance. In my view, sir, removing third-party appeals would weaken the balance, and retaining them would strengthen it. The inclusion of third-party appeals is proportionate, carefully targeted, and part of a package of safeguards that ensures assisted dying can operate ethically, safely, and with public trust. It protects individuals, supports lawful decision-making, and reassures the community that the system is robust. And for these reasons, sir, I urge members to support it. Thank you.
Thank you, Minister. Deputy Captain Curtis, did you wish to speak? Yes.
Thank you, sir. Just a few words. Concerns around third-party appeals occurring while a person has chosen to go forward with an assisted death outweigh any safeguarding points. Extra safeguarding could have been established with some of the amendments already debated and voted against yesterday and this morning. Third-party appeals work against autonomy. It allows someone to put a stop to a process which a person has chosen to do in sound mind and knowing what's best for themselves. Third-party appeals are unnecessary and may be used in a coercive way despite any conditions applied, and therefore the review panel brought the amendment to remove the third-party appeal.
Thank you, Deputy. Deputy Scott.
Sir, I've considered this amendment very carefully, and when I tell constituents that I supported an assisted dying law, I said that I would look very carefully at the safeguards. And this is a safeguard, and an important safeguard. And yesterday, somewhat unfortunately, I believe, in the context of what I believe has been a respectful debate, the name of a doctor who was known as the Doctor of Death actually was mentioned in the context of this law. That there could be that possibility that you have somebody who somehow has got in the system who makes a decision that is inappropriate, that somebody actually who perhaps doesn't have 6 months left to live or isn't suffering, or gets the sanction, the sign-off, yes, go ahead. And I believe that this is what this safeguard is about, and that I believe that the scrutiny process has looked at certain things, and I note the grounds for which they brought this this proposed amendment. But I believe on this occasion that the fear is misplaced. It's not about having relatives just say, I don't like that decision, so let's stop. They can't do that, not under this provision. It is about actually somebody exercising a clinical judgment that actually should not have been made. So on that basis, I urge members to reject this amendment.
Thank you, Deputy Scott. Does any other member wish to speak? Deputy Ward.
Thank you, sir. This is an important debate, and we need to voice our concerns in every area. So this is about whether we allow people to challenge a positive eligibility decision made for a capacitated adult who met every safeguard, every assessment and every requirement set in the law. The panel's amendment, I think, is clear and targeted. It deletes the statutory right of appeal for persons with a special interest, and it does so for good reason. The panel's report makes the point plainly most jurisdictions permitting assisted dying do not allow appeals by anyone other than the applicant. That is the norm internationally. One comparator, that of Queensland, that is anything similar, and even there the advisors found no reported cases or relatives or other appealing a positive decision. No evidence of misuse, no evidence of a problem that Jersey needs to solve. And we have a number of safeguards in place. There is a very staged process to an assisted dying eligibility. The UK's terminally ill adults bill, which has been scrutinised intensely, very intensely, also contains no right of appeal by an interested person. The only right to challenge a decision is with the applicant themselves. I question why Jersey would choose to be an outlier. Why would create a mechanism that no other jurisdiction has found necessary or appropriate? So I don't believe this is just a policy question. It is a human rights question. I have to say, the phrase that it would have limited interference in human rights seems slightly odd to me. Human rights are human rights. We can't pick out particular little parts of it or sections of our community that we consider won't have the same human rights as everyone else. I would be firmly against that. And the interference in a person's private life, autonomy and medical confidentiality, I think are very serious issues. I think of myself as an autonomous individual making decisions about my medical situations, wherever they may be. I want to have that autonomy. It's my right about me. The panel also notes crucially that human rights analysis accompanying the draft law does not specifically address the additional interference, and that's a really important thing that's missing. So I remind members we're dealing with competent adults who have been assessed as having mental capacity. That assessment is a key part in the beginning of the process. And adults who have made a deeply, deeply personal decision about their own end-of-life care. Allowing others to challenge that decision, potentially against their wishes, creates a real risk of violating that autonomy. And it is incompatible with Article 8 of the ECHR, as mentioned by the chair of the panel. And that's not a risk that we should take lightly. I question the issues around who has a special interest. I'm not entirely certain, sir, that that's clear enough, because it is for the court to decide who qualifies, and therefore the category could be wide and uncertain as we build up case law. And I think if there is a slippery slope, it's there. But, sir, the uncertainty therefore invites conflict, delay and litigation, and I think that goes exactly against the type of assisted dying law that will be that I want to see enabled over this week. It risks turning a clinical pathway, one already governed by multiple safeguards, into an adversarial legal process. It risks putting family members against each other at the most emotionally charged moment imaginable. And as the panel warns, it could lead to delays in the applicant's pathway, adversarial proceedings at a sensitive time, undermining of coordinated clinical assessments. And those assessments for assisted dying are coordinated. They have to be to get through the process. And it increased litigation and conflict. None of this helps the person at the centre of the process. None of this strengthens safeguards. It only adds frictions, uncertainty and distress, in my view. And that brings me to the final point I'd like to make. There is no safeguarding app that third-party appeals would fill. The Jersey model already includes 2 independent medical assessments, capacity assessments, examination for coercion, multiple procedural steps, and an oversight by the Assisted Dying Delivery and Assurance Committee. The panel does say they found no safeguarding gap that would be filled by third-party appeals, and I do agree with that. In other words, the system is already strong. Adding third-party appeals does not make it safer. It makes it slower, more adversarial and intrusive. So I would just say that on this occasion, I do agree with the panel. I know I haven't previously on a couple of others, but I would urge members to accept this amendment because it gives, this is as much about autonomy and rights of the individual to make decisions about their own end of life as anything else. And we need to keep sight of that when we make decisions in this assembly. So I urge members to accept this amendment. Thank you, sir.
Thank you, Minister.
So
Minister for External Relations.
I just have a question for the Attorney General designate. He earlier, in a previous amendment, suggested that it was his view and the view of his department that the legislation as stands was compliant with human rights. We've just heard from the last speaker casting doubt upon this element of the legislation being compliant with human rights. I wonder if he could just clarify for us, please.
Mr. Acting Attorney.
Yes, of course. I think the phrase used was by another, probably one of the experts, potentially incompatible. Well, many things can be potentially this, that, or the other. Human rights considerations usually involve a balancing exercise between competing rights. And the two that are in competition with each other here are the Article 1 right to life, which is absolute and unqualified, and the Article 8 right to a private life, which is a qualified right. The approach that the European Court of Human Rights have taken on this whole topic is that an assisted death may be part of the Article 8 right to a private life. It leaves it open to jurisdictions to decide whether they wish to have an assisted dying service or not. It says if you are going to have one, however, you must ensure that it contains sufficient safeguards, that it does not amount to or is not incompatible with the Article 1 right to life. The way I think of it is this. As I've said, the assisted dying may be part of the Article 8 right to privacy, but it's not mandatory. It's for jurisdictions to decide for themselves. Assisted death services must provide sufficient safeguards to protect the right to life. The tests under this third-party appeal are these: that the health criteria decision was irrational, and that in other respects, in respect of other decisions, the decision maker did not comply with the procedural requirements that the law placed upon him or her. And I suppose the question for members to consider is this. Is it a safeguard to ensure that there is a challenge to decisions that are or may be irrational, or a challenge to decisions that fly in the face of the procedural requirements of the law? And does that safeguard, if that is what it is, serve to underpin the efficacy of the law? Because if decisions can be made irrationally and are not subject to challenge, if the procedure can be honoured in the breach but not followed, then those are things which serve or may serve to undermine the legitimacy of an assisted dying process. And so these are big issues, and I don't think it is as simple as saying that the third-party right is in breach of Article 8. It's arguable that it might be. It's equally very arguable that it's not. I hope that's helpful.
Deputy Scott, you indicated that you had a question for the Attorney.
Yes, and it was along the lines of the question that was asked by Deputy Gorse, because in fact in the comments produced by the panel, they were saying that the advisors cautioned that what we currently have with a third-party appeal may be incompatible with Article 8 of the Human Rights Law. But the question I have, having heard the Attorney General's response, is that he has basically been talking about the balance of the two human rights that are involved in considering the assisted dying law, and this right of privacy and the right of life. This is very much, I understand this is the only time when a decision that is irrational or illegal can be challenged under the law, I believe. And that, and I think some of the concerns is that, well, it could be, bearing in mind that relatives can't just say, I don't agree with that decision about life generally. that insofar as there were concerns that this could be used in some way to interfere with someone's right of, to make that decision, what happens at the kind of the court process? I mean, before it even could be considered, is there an initial decision? What's the kind of evidence that had to be produced by somebody challenging this to perhaps give some, comfort that it can't just be used as a delaying technique or to interfere with somebody's, decision to exercise their right to have assisted death?
Mr. Acting Attorney, are you able to assist with what happens practically in terms of the court process?
To this extent, it remains for the court to make rules of court which will set out how it will deal with third-party appeals in practice. As with any forensic process, if the challenge to a decision is that it was irrational, one would expect that the court would wish to have some evidential foundation upon which to conclude that it was or it was not. If the assertion made is that other decisions, other than health criteria decisions, did not follow the procedural requirements, again, a court would want to have some evidential basis upon which to consider whether that was or was not the case. I remind members that the deadline that this law would propose to set for the determination of such appeals is very short. I think it's 28 days. I'll double check if I'm wrong about that. But the whole impetus is that there shouldn't be extensive and time-consuming litigation. A decision should be made very swiftly.
So, sir, just to follow up on that then, because 28 days still sounds like a long time, just practically, bearing in mind the context, and I understand that court rules haven't been drafted, but bearing in mind the context and the import, so it will take a while for the, I'm just trying to understand practically how within what time period might you expect that court to look at this initial evidence and just say, well, because otherwise there's that danger of staying a decision whilst the court considers this decision. And what we're learning is it could be up to 28 days. Practically, in the kind of context of what 28 days could mean in all this, what is likely to be the turnaround sort of decision, or just looking at that decision to decide whether it's vexatious or not?
I should just correct what I said earlier. The 28 days is a reference to the time within which the third-party appeal must be lodged with the court. Paragraph 4 of Article 42 then provides that the Royal Court must determine the appeal as quickly as reasonably practicable. Now, I would be entirely ultimately in the court's hands as to what that means in practice. I couldn't offer any sort of authoritative view on that today, but it is clear that the law anticipates that the court must act as quickly as practicable, and one would expect that the island's judiciary will have that very much to the forefront of their minds if they deal with such appeals.
Treasury Minister, did you have a question for the Acting Attorney? Deputy Tadier, you were looking at me. Did you?
Yeah, I was to speak, sir, but I don't know if all the questions are finished. Sir, this is a difficult one, and I'm not suggesting the other ones haven't been, sir, but I think this is one debate where I've come into looking for answers, sir, and I'm not sure that I found them yet. When I initially saw the amendment from the scrutiny panel, my reaction was, why do we even have third-party appeals in the first place? It sounds instinctively wrong. Then I spoke to the Minister, and he gave some assurance that this is a very limited area, and it's to do with, as he's explained and as the law explains, about if there's been an unreasonable and irrational decision from an individual. The concern I have, sir, still remains, and that there are a number of concerns, in fact. The first reason is it's fair enough to say that somebody can't put an appeal in simply because they don't like assisted dying, they don't agree with assisted dying per se, or that they don't agree with the person's decision to have an assisted death. But of course they're not going to say that, are they? So no one's going to put an appeal into the court saying, I don't agree with the assisted dying. They're going to put an appeal in perhaps entirely for legitimate reasons. It may even be someone who does support assisted dying, but has a concern. So I'm really going to just refer to the notes that I've got here, just so I don't divert too much from the path, sir, because this is quite a complicated area. So that's the first point, is that, of course, and that's what I asked in my question to the Attorney General designate earlier, was that how do we know that this can't be used vexatiously? And so not only would I want to think that there is a threshold that needs to be proven in court, but I would have thought that there should really be a requirement to get the leave of the court to even submit this, to make sure that there's a prima facie case against the medical practitioner that the decision has been unreasonable, so that there should be reasonable grounds to even have to lodge the proceedings with the court. I've written here that if a medical professional is making a decision that no reasonable person would be making in her or his position, then we have a problem. And that if we have to rely on a third-party appeal to pick up that problem, that medicinal practitioners are making unreasonable and irrational decisions, even though there are other safeguards, and it's not just one practitioner that's making that. I understand that there's always a safeguard there, that it's got to be signed off by two of them, then that's an issue for even to get to that stage. And if on top of that, a third party has to then use a judicial legal route to the court in order to get a resolution on that, then I think we have a bigger problem. And the question I ask instinctively is, what's the difference between this mechanism and just a more general whistleblowing policy? So if somebody becomes aware that there's some misuse, or that somehow after a number of years the system has gone off in a different direction, and the suggestion here is that doctors are somehow signing off people for an assisted death that they shouldn't be, that they're saying somebody's got 3 months to live when in fact they've got an illness which is entirely curable and that they're not dying, then of course that's a very hypothetical and extreme example, and it shouldn't rely on a third-party appeal process to do that. There should really be a whistleblowing policy that you might want to be able to refer that to the assisted dying regulator, for example, or to the Care Commission, or to the professional body for which those GPs, those medical practitioners are registered with. So I remain to be convinced that a third-party appeal mechanism, especially given the fact that not only does it take time for the court to convene itself, I mean, as fast as reasonably practicable doesn't give me any comfort as to how quickly that would be, given the fact that, no disrespect to the court system, but it can work quite slowly, as we know. It's not an equivalence at all, but I'm mindful that it takes 3 months for the licensing bench to sit, and I hope that wouldn't be the case, but I don't know if an emergency button could be pressed and that the court could be convened within the space of a few days to decide on an assisted dying third-party appeal. And if it couldn't, would there be almost an administrative process to do that through an expedited system, sir? So I think there were lots of questions. And notwithstanding that point, it can take up to 28 days for that third-party appeal to be put in place anyway. So somebody could wait till the 28th day, a third party, and then put the appeal in, and then of course it will take the court a reasonable amount of time to get themselves together at all. What if the third party is doing it for all the right reasons, as we hope they would be, but they simply don't necessarily have the wherewithal to cope with the procedures of the court process to do that? And what indeed if the individual who is waiting for their assisted death doesn't agree with the third party appeal? How do they contest it? Are they, from their deathbed, literally, are they supposed to start convening legal representation to fight a third-party appeal? So I think in this area there are lots of questions which are still outstanding in my mind, which don't speak one way or the other to the desirability of a third-party appeal process, but actually to the mechanics and logistics of how that will work. And unless the Minister, or perhaps even he's spoken already, but when the Chair sums up, I think it's a case of maybe erring to the side of caution. I'm not sure which side that will be, but bearing in mind that there is still time before this legislation comes into effect in, I'm sure, at least 2 years' time, maybe longer than that, for greater consideration to be given to this. So I am mindful of the fact that it is useful, I think, to have a safeguarding measure which is equivalent to a whistleblowing policy, but I would have thought that whistleblowing policy should be there to flag up any unsuitable individuals, but any very suspect decisions that get made. And I just wonder whether the appeals process to the Royal Court is the best way for putting that safeguard in place, sir.
Thank you, Deputy Tadier. Deputy Renouf, I think you had a question for the Acting Attorney.
I do, yes, and I'm very reluctant to add to the debate, but Deputy Tadier raised a point which I think certainly interested me, and it concerns this business of vexatious appeals possibly being used to slow up the process. The Acting Attorney General has already said that nothing can stop vexatious litigants. But what I wanted to know from the Acting Attorney was how quickly would such a decision potentially be made, given the requirements that he's already outlined in the law to act as quickly as possible. If a person is morally opposed to assisted dying, for example, but is using a procedural device to try and thwart an assisted death, how quickly in those sorts of circumstances might a court be able to deal with that question rather than have to go through, for example, a whole process, a whole sitting?
Thank you.
Well, can I just clarify, when I talked about you can't rule out the possibility of vexatious litigants, you can't rule out the possibility of people making bad applications. Our courts are very good at weeding them out at an early stage. It remains to be seen what rules of court are created if this legislation is adopted. The fact is that our courts can and do deal with emergency applications at very short notice, very expeditiously. What might they require in the particular circumstances of this case? Well, that will be a matter for them. But at the very least, they might want to see immediately whatever medical report was used to justify proceeding from one stage to another. But our courts can and do, in all sorts of areas of law, deal with urgent applications, and as I say, deal with them very swiftly.
Thank you. Deputy Balash, you indicated that you wish to speak.
So I dissented as a member of the scrutiny panel from this amendment, and I would just like to say that I think that in this case the Minister is absolutely right. It is a safeguard which is important, and it's of the essence of all safeguards, I think, that they may not arise very often. But when they are needed, of course, they are important. Deputy Tadier seems to be contemplating that there ought to be some other kind of safeguard, but not an appeal to the court by a third party. But there's no amendment to that effect before the Assembly at the moment, and we are concerned with this third-party appeal. The reasons given by the panel don't seem to me to be very persuasive. As the Minister says in relation to international practice, we are entitled to set our own safeguards which are appropriate for Jersey. The Acting Attorney General, I think, has dealt very well with the human rights arguments, which have no substance at all. And as to confidentiality and clinical integrity, it seems to me that it may be, in a particular case, very important, as I think Deputy Tadier hypothesized in relation to decisions by medical practitioners which are wrong because they contemplate a death within 6 months, whereas the patient may not be suffering from that kind of illness at all. And those are the kind of situations where sensitive medical information must be placed before the court, because otherwise the court is not going to be able to do justice to the case before it. I think that it is really important that a close member of the family, and such a member of the family would have a special interest, a close member of a family who is concerned that for whatever reason, a close relative has been persuaded or induced to seek an assisted death when the justification for that death is not there, should have the right to take the matter before a court. And I speak from personal experience. The Acting Attorney General is absolutely right. The court is capable of acting with extreme expedition when the circumstances require. And I'm sure that rules of court in due course will ensure that any appeal of this kind is one that is dealt with as a matter of urgency.
Thank you, Deputy. We've reached the point in time when I'm required under standing orders to remind members of the adjournment for lunch. Are members minded to adjourn at this point, Deputy Scott?
Sir, I had one more question of the AG, which we could just get sorted before the lunch recess.
Very well. Perhaps if you could ask your question and then...
Thank you. Because it follows up from Deputy Tadier's a comment about would a whistle policy, a blowing policy do? And I am conscious that in the UK, at least, there was a case about a nurse called Lucy Letby or someone where a whistle policy was used and nobody would accept there was anything wrong. But if, and here's my question, if a whistle blowing policy was developed and used, and actually it was used to stop a procedure that had been started under law, would the relevant people who stopped that procedure, given that it's a procedure under law, have legal protection themselves without anything specific in the law?
I'm really not sure I understand what I'm being asked.
Could you help the acting attorney with what you're actually asking, Deputy Scott?
I'm saying, in the absence of a specific provision in the law enabling somebody under a whistleblowing policy to interfere with a process that's set by law, would there be legal protection for a person who did that?
Well, it rather depends what they were trying to do and with what motive. If they were trying to coerce improperly, they might commit an offence. So I'm not sure it's a question I can answer. If that is sufficient answer, there's clarification I should have given earlier, which it might help the Assembly if I give now about rules of court.
Yes.
It won't take long. Article 98 of this draft law provides this about rules of court. The power to make rules of court under Article 13 of the Royal Court Jersey Law 1948 includes a power to A, regulate and specify the procedure for an appeal to the Royal Court under Article 42 against a decision made under this law, and B, provide for those appeals that relate to the age and residency criteria or relate to another matter specified by the rules to be determined on the basis of only filed documents and not an oral hearing. Remains to be seen what rules of court, as I say, are drafted, but that anticipates a truncated process for at least some of the issues that might be taken on a third-party appeal. I hope that's helpful.
Thank you. Are members minded to adjourn? Thank you. We stand adjourned until 2:15.